Morning, everyone. We have three cases on this morning's calendar. The first of them is LATEEF RASHAD SHARPERSON versus United States, number 25CO29. And we'll hear first from counsel for Mr. Sharperson.
Your Honor, may it please the court. Justin Ocasio for Mr. Sharperson, Your Honor. On his behalf, we'd like to reserve 3 minutes for rebuttal. Your Honor, the Superior Court, in denying Mr. Sharperson's 23-10 motion, committed 5 separate and independent prejudicial errors, each of which should result in this court reversing and remanding to the Superior Court. First, the trial court relied on lead counsel's declaration over defense counsel's objection, which is in contravention of Thompson versus U.S., a recent case of this court. Second, the trial court, when considering Mr. Sharperson's claim that trial counsel failed to adequately prepare him to testify, did not consider and discuss the critical issue in that situation, which was the trial counsel's failure to play Mr. Sharperson's jail calls and statements to the police to Mr. Sharperson while he was in custody to prepare for his testimony. Third, the trial court committed several errors in denying the motion relating to the jury having seen him in custody. Namely, first, the trial court said that it was, quote, sound trial strategy for trial counsel to have done nothing at all, not even asked the trial court for some potential remedy. Second of all, no remedy was requested, such as a limiting instruction or some level of hearing to at least find out if the juror that heard the issue or saw it should have been excluded potentially from the jury. And 3, misapprehended the prejudice arising out of the jury knowing about Mr. Sharperson being in custody. Fourth issue, Your Honor, is trial counsel did not obtain a medical expert to help him understand. First of all, consult with this expert to help him understand the issues that were related to the medical testimony by the SANE nurse. And when he did cross-examine the SANE nurse, it was evident that he did not understand the testimony, and things came into evidence that were just clearly erroneous mistakes that were never clarified. During the 23-10, Mr. Sharperson's counsel admitted an affidavit without objection by the government that explained some of these errors and what would have happened differently if that person had been able to testify at the trial. Fifth, trial counsel failed to advise Mr. Sharperson of the right to request a lesser included instruction and did not request a lesser included instruction, which would have been granted if it would have been asked for. Namely, simple assault was an available lesser included for first-degree sex abuse.
Can I ask you, taking you back to your first issue,
That's right.
There's a funny wrinkle in the case that I'm not sure your briefs fully zero in on, which is, if I understand the record correctly, the trial court, although it later did refer to the affidavits and rely on them to a degree, the affidavit of Mr. Long and rely on it to a degree, the trial court actually didn't admit that affidavit into evidence. There was a discussion. Originally, it seemed like it was going to, and then the United States, as I read the record, withdrew its request to have it be considered. So is that your understanding of the record as well, that the trial court actually didn't admit it and instead it wasn't even ultimately offered?
Well, I think technically speaking at the hearing, Your Honor, was correct that the trial court, the trial court said, I can consider everything in the record. That's what the trial court said. And that's early on.
The trial court initially said, when this issue was being raised, the trial court did initially say in a passage you quote, it's in front of me, so I can consider things that are in the record. But then started asking, why should I consider it and all that? And ultimately, the United States, after the passage you're describing, said, well, we're withdrawing the affidavit. So I would have understood that it was just not actually admitted and that there was an error, leave aside whether hearsay can be considered or not, a related but distinct question. I would have thought there was an error in that the trial court in its order relied on an exhibit that the United States withdrew and that was never admitted.
That's a great point, Your Honor. The way I saw it, because I was at the hearing, I was counsel at the time, and so I went through it and I read the transcript in context. The way I understood it from reading the trial court's order is that is one way to attack it, but the way I saw it was at the beginning or early on, the trial court said, I can consider everything in the record, was very clear about that. When the prosecutor started, when I objected to the affidavit being entered, and we only objected to that one, by that one counsel, not by the other person who testified. At that point, there was a back and forth And at some point, the government backed away because I think the understanding was that I can consider everything in the record, so she was going to consider it anyway, potentially. And she did consider it because when the court reads the order, she did consider that evidence. So I have to say that that's a good point. If it were a jury, a situation where, for instance, evidence went to a jury, that would be an issue we would raise on appeal. I think in this case, it's kind of subsumed in the fact that she considered it, we objected to it. And you know, whether or not it was technically admitted or not, which, you know, that's a good point, but I think she did consider it, and she did say she was going to consider the whole record. And when you read the order, Your Honor, she did consider what she thought was the whole record, which is essentially that. So it's, Your Honor has a good point procedurally. I think that in the essence, in this situation, that made no real difference in the way it was reviewed, because it wasn't an exhibit going to a jury or something of that nature that was erroneously admitted. It was her saying, I can review the record. And now we read, when I got the order, we read, this is what the record means in her mind, which is everything that was admitted during the pre-evidentiary hearing. Meaning,
Oh,
Yes,
sorry,
Your Honor.
Counsel. So one thing the government says is, okay, but the only three discrete senses in which the trial court relies on that affidavit, it simultaneously relies on credited testimony from the second chair, Mr. Stovall. So sort of who cares, being the takeaway from the government's argument. This was something that was backed up by otherwise credited testimony. So we couldn't attribute any, you know, real damage done to the error you're complaining of if we thought it was error.
If Your Honor parses it that way, and the government, I mean, they have their point is, let's look and see where trial counsel, Mr. Long, is actually mentioned in the order. But then when Your Honor looks at in context is everything, as the court said in other opinions, Your Honor will see that Mr. Stovall, the one who testified at the hearing, he very clearly said he doesn't know about several parts of what happened. Also, he was not the lead counsel. So he did say some things that did come in, and we didn't even object to his affidavit because he testified, and it was fine. But what the trial court's, the content of the order, including sound trial strategy, what the strategy of the trial counsel was, things of that nature, things that happened, it was a lot of it was implicitly drawn from that order, because it didn't come out of Mr. Stovall's mouth. It wasn't in his affidavit. So
can you just remind me what the critical, so that Mr. Stovall had no idea if Mr. Long had reviewed the prior videotape statements with the client?
Correct. That's one thing he had no idea.
And what else do you want me to keep in mind?
He also, as far as the custody, he didn't know about the custody situation and what happened, or whether Mr. Long had made a decision. He wasn't there for the preparations as far as the strategy going in. He was really truly a second chair, which is he was there to help us with some discrete issues, but he didn't know. And I asked him, and we weren't trying to play hide the ball. What did he know? And he also said that he just didn't know about he was there for Mr. Sharperson speaking with Mr. Long about him testifying, but not about was there a mock that done, the specifics about what he'd ask him, things of that nature. So there was a lot that he didn't know about, and that was in the order. So
Can I ask you just to shift about that? So take that as a given. On your theories of prejudice, at times, relative to this component of your claim, at times the suggestion is that your client would not have testified if he had been adequately prepared about the risks of cross-examination. Is that a part of your theory of prejudice that you're pressing in this court, or is instead, and you can press both of them as alternatives, I guess, but in any event, if he had testified, the cross would have gone better because he would have been better prepared, and certain of the impeachment incidents that occurred during trial would not have occurred. You're making both those points in this court, or are you not so much making the I wouldn't have testified point?
Okay, I'll answer the question, but before if I could just to give some context to it, the government talks about the harm, and I want to make sure the court knows that, and Your Honor knows this obviously, but just to say it out loud, the cumulative error of all the prejudice of all the errors is how the court would judge this, and that's in Strickland itself, which says trial counsel's errors, and also in Truesdale, and also
Understood. All deficiencies would have to be cumulative. I get that.
Well, Your Honor, initially the initial theory was that he would have been prepared properly, and he would have testified, something would have been different. He testified at the hearing, and this is why the hearing is so important. This is kind of interesting you're asked this, Your Honor, that these 23-110 hearings, so much comes out that changes the whole tenor of the actual case, people have affidavits, they think that this is what happened. And when it comes down to when they're pressed and they actually get up on the stand, they say things that are not always expected. He said on the witness stand, when he testified, that he wouldn't have, he wouldn't have testified if he had known about these other impeachments. If he had known that what would have come in against him, he wouldn't have testified. That's what he said on, and when he
Right, and the
testified at
trial
the
court
hearing.
didn't credit his testimony on
Yeah,
this issue, so
well-
I'm not sure how helpful that is to you unless you think the trial court's credibility determination was unsustainable.
Okay, well, I mean, she said, that's another thing. I mean, she says, I don't credit his, does that, I don't think her order said, I don't credit anything he said at all, period. I mean, his name and what happened, I mean, she didn't credit certain parts, that's another issue, but that being said, I think both sides of it, Your Honor, in Truesdale, which this court recently decided, the defendant was prepared, but not prepared well by the attorney. The attorney testified at the hearing, and at that hearing, the attorney explained, and this is all in the order, that he was overwhelmed at the time. He didn't understand, apparently, the felony murder doctrine as applied to Mr. Truesdale. And when he testified, Mr. Truesdale, he was cross-examined viciously with all kinds of things that he didn't expect. And then at that point, that was the error. And in fact, in Truesdale, Your Honor, this court cited the same case that I cited in our brief in the Ninth Circuit case.
And if you were gonna, in this case, like, what's your best point you would make about here is a thing that happened during cross that was really damaging to your client during the trial that competent representation would have prevented because ... leave aside not testifying, but assuming again the alternate world in which your client would have testified but would have been better prepared. So what's the most concrete example of the most damaging piece of cross-examination that you think would have been avoided by adequate preparation?
Yes, Your Honor. So he made some statements on the stand that didn't match what he had told people before in other situations. So some of that, as a defense attorney, and we're trained in this, is that people sometimes don't remember and there's confusion. And sometimes the statement that is used against the person, this was actually an issue, for instance, under Rule 16 in Rosser and also in Yoon, which is, yes, you made the statement, but the person has a right to see the statement, understand it in order to prepare to jog the memory, in order to testify in a way that would allow that statement not to be taken out of context. So for instance, him saying the reason why he picked up did he pick up the two ladies? Did he mean to pick them up or did he leave? Also, did he call 311 and 911?
Those examples seem, I mean, obviously it's not helpful to have your client ever impeached with, I'm saying something about the incident that's a little different than I said before, but those seem on relatively collateral points rather than things that are central. Or do you think there was impeachment on something that was really critical as opposed to more tangential?
Well, Your Honor, that's a great point, Your Honor. The reason why it's critical is when the person, if he had known and he realized, oh, I said that, okay, when he was asked, and this court has said this before, defense counsel would have taken the sting out of him and said, hey, did you say something different before? Oh, yeah, I did. Why? Well, let me tell you what happened, and here's why I was in this situation. This is what I thought happened. Or he might remember what really happened and testify consistently with the prior statement. But at the end of the day, when he's not able to know that, he puts all of his cards on the table, and then he gets up there and the prosecutor crushes him and shows that he is a liar. He lied about the 311 911 call. He said that he didn't call the police for one reason. It's another reason. He said he didn't go get the women for this, but he did for that. It undermines his entire credibility. This is a case where it's two people in a car, and with him on the witness stand, he's now putting his essentially his character, although not legally, but in a sense, his statement is being used against them. Now, if he hadn't testified, Your Honor, the government argues that they had a compelling case. Not really, because they have a woman who's caught allegedly having sex in a car with somebody, and someone discovers this person who had.
You say allegedly. I thought your client testified at trial that they were having a
Well,
sexual encounter. So I
I'm
didn't
saying
think
if he
that
didn't
was
testify, I'm
disputed.
saying in a world where he doesn't testify, someone comes in, there's an incident happening. She says something, some of that may or may not come in under battle, some of it won't. There's a man who discovers them who has a gun. She lies to the police later on about this man. Understandably, I mean, there's a reason why, perhaps, but she still does lie to the police. There's not a lot of evidence really about what really happened, and that there was, it was the force that was used and things of that nature. So,
Counsel, what's really left of his defense then if he doesn't testify about consent?
that what she's saying is not accurate, that she fabricated it because they were caught maybe making out, and she says something that to somebody at some point that wasn't accurate. And in fact, the 911 call, which this is not part of this actual appeal, but she does tell her mom, I wasn't raped. I mean, there are things that would have come in that would have changed the balance in that situation. It would have been a one witness case, and the corroborating witness is a person who has a gun, who might have been carjacking them or might not have, we don't know, but he actually was committing an offense at the time, maybe, or maybe he was a good Samaritan. So I think that looking at it from that perspective, it's not a compelling case necessarily, but when he gets on the stand and says A, and then it's really B, then the jury says, well, this guy must be lying. That's why you don't put your client on the stand when they're going to be impeached for something, and you want them to be prepared.
Well,
They-
I've seen plenty of transcripts where people put their clients on the stand who are impeached on things. Sometimes that's your best strategic choice.
It's-
Witnesses have baggage that's
Yes, sir.
intrinsic. but-
If adequately prepared, and that's what Truesdale was saying essentially, which is.
Can I ask you,
in that
counsel,
case- Yes,
you're over time.
Oh, I'm
You
sorry.
had you have a series of points you wanted to make. If there's one that's critical that you want to try to speak to for a minute or two before we move on, I'm happy to give you a chance to do that.
Thank you. I appreciate that, Your Honor. Just, I wanted just to drive home the reasonable probability standard, which the court knows, but, so I'm ashamed even having to say this, but I just want to say it because, for the record, the government talks about it, but they don't quote the entire quotation that this court and the Supreme Court has talked about, which is, a defendant need not show that counsel's deficient conduct more likely than not alter the outcome of the case. The result of a proceeding can be rendered unreliable and hence the proceeding itself unfair, even if the errors of the counsel cannot be shown by preponderance of the evidence to have determined the outcome. And that's Dominguez, U.S. versus Dominguez, 2004 Supreme Court case, which drives home the point that reasonable probability standard is not the same as and should not be confused with the requirement that the defendant prove by preponderance of evidence that but for the errors, things would have been different. So we have 5 cumulative errors here. Even if Your Honors don't find all 5 of them to be compelling in and of themselves, I think in a case like this, especially with the medical evidence and other things, Your Honors can find that is sufficient to reverse and to remand, especially because the trial court didn't even make findings about some of these things. There was no prejudice finding. And Your Honors, although you're reviewing prejudice de novo, there's not a finding of prejudice in the first place because in the issue with the testimony, whether or not he was shown the tapes and also with the custody, she's not finding, the trial court didn't find prejudice about the custody. She just kind of, the prejudice, the analysis is either wrong or missing. So I think for that purpose, just alone, that Your Honor should review what's been decided, and if there's no prejudice decided and there's deficiency found on appeal, it should be sent back for that alone.
Thank you, counsel. We'll give you your 3 minutes in rebuttal.
Thank you, Your Honor.
May it please the court, Timothy Cahill for the United States. Trial court did not abuse its discretion by giving limited consideration to the affidavit of Mr. Sharperson's deceased lead trial counsel, where counsel's unavailability was not attributable to either party, and the affidavit had significant indicia of reliability.
Can I ask you what, I mean, as I looked over the transcript again, I can see it's a little blurrier than I originally thought. Is it your understanding of the transcript? I'm talking about like pages 99 and 100 of the hearing transcript, that the affidavit was not evidence to be considered by the trial court in connection with this? Or do you read it more as your opponent seems to have, as perhaps it was withdrawn only for purposes of what was going to happen on the hearing that day, and instead it was appropriately considered? Your brief referred to the exhibit as withdrawn, and didn't say that it was actually admitted. So I'm a little unsure what your position is about whether it was evidence to be considered or not evidence to be considered.
So I think of the two scenarios, Your Honor, I think it's closer to the latter. I think our understanding of what the trial court did and the party's understanding at the hearing is actually consistent with what appellant's counsel said. I think the trial court draws a little bit of an odd distinction here that I don't, which might be error. If it is, I think it's harmless error because I think all the parties understood what was happening. The trial court draws a distinction between what was literally admitted at the hearing, but then also makes clear that it doesn't view that as the limit of what can be considered. And so I think appellant's counsel made clear that it objected to the affidavit being considered at all. The government made clear that it thought the affidavit could properly be considered in resolution of the 23-110 motion, and the trial court made clear that it believed it was appropriate to consider it. And then, as sort of what the trial court seemed to view as a technical matter, said that, well, given that I view this as something I can consider, will the government withdraw it just for purposes of this hearing? And in that context, the government said, I mean, if the government says that's fine, then Your Honor, and then says I'll withdraw it. So again, I don't know that there's any weight to be put on that distinction.
I have to say, you've acknowledged, I guess, I don't quite get why the trial court would be admitting it for purposes of ruling on the motion, but not admitting it for purposes of the hearing. If anything, if it's going to be part of the evidence that's going to be ruled on, it should be admitted for the hearing so that people can respond to it at the hearing.
I agree, Your Honor. I don't think that we're not asking the court to put any meaningful weight on that distinction. To the extent the court views that as some sort of technical or procedural error, again, we would submit that that's harmless. Again, given that both parties and the court seem to understand, even if they didn't all agree, they seem to understand that the court's ultimate ruling, even at the hearing, was that it viewed it as appropriate to consider this.
You would say it was effectively admitted for all intents and purposes. Is roughly your position?
Yes, I think that's a fair characterization, Your Honor. In any event,
can I just ask,
yes.
the trial court, I take it you agree, the trial court can apply the rules of evidence at a 23-110 hearing, right?
Yes, I think that's correct.
I think you would agree that this affidavit would not have been admissible under the rules of evidence because it doesn't satisfy any of the hearsay exceptions.
That's correct.
But I also take you to say, well, it's kind of discretionary if you want to apply the rules of evidence. And here's all sorts of factors that I agree, especially particularly the attorney's unavailability, would make a pretty good case. So you could have a good equitable ruling saying, for all these reasons, I'm going to consider it. Does the trial court's reasoning look like that? Because with the trial court, I mean, I was sort of, I take your point. A trial court properly exercising its discretion, I think, could properly consider this. But instead, the trial court says something that is a little bizarre. Sort of anything I want, anything that I want to consider. If it's around, I can consider it. And that seems wrong. So I don't know what to do with that, but I don't know if you have a reaction to that line of thinking.
Yeah, I think our reaction would be that the trial court's order could be more clear on this front. I don't think there's any way around that, but I do think that the elements of this affidavit that the government highlights as making it sufficiently reliable to be appropriate in a discretionary setting for the court to consider are all noted by the court. The court specifically describes the affidavit in its order as an affidavit that was submitted under oath. It notes that it was submitted as part of the 23-110 proceedings, that it wasn't some freestanding previous document, that it was submitted in proceedings where if Mr. Long's tragic death had not happened, there was every expectation by him and everyone that he would have been subject to cross-examination. And the court also notes, even if it doesn't expressly put it in these words, notes that it's corroborated by Mr. Stovall's testimony, given that for everything that it cites Mr. Long's affidavit, in the same citation, there is a citation to Mr. Stovall. And I did want to emphasize that in response to one of appellant counsel's arguments about some possible distinctions between the scope of knowledge of Mr. Stovall and Mr. Long, that none of those were the things that, for example, about the video calls or the custody issue, those were not the things that the trial court cited in that one paragraph, the only place that it actually cited Mr. Long's affidavit. And the only place it actually cited Mr. Long's affidavit, each time it was adjoined by a corresponding citation to Mr. Stovall's affidavit of something, or Mr. Stovall's testimony, something else that Mr. Stovall corroborated.
Does the trial court, I just don't remember from its order, does the trial court, without citing to Mr. Long's affidavit, sort of credit things that only could have come from Mr. Long's affidavit? Does it say, the attorneys went over the video evidence?
It does not say that. But so the only point that I think, and I think we acknowledge this in our brief, the only I would say is relatively specific point in the context of this, that it says is it cites Mr. Long's or cites the idea that a mock cross-examination specifically was conducted. And I don't believe that Mr. Stovall acknowledged he did not have a specific memory of that, and that does appear in Mr. Long's affidavit. That said, Mr. Stovall testified that there was preparation done about how Mr. SHARPERSON should answer questions on both direct and cross-examination, that questions were gone over with him. I mean, drawing it to that fine of a distinction, we would maintain, that this would be harmless error, even if it was error, which of course we don't believe it was error to consider it. But even if it was, we believe that would be harmless. And also the limited nature of this consideration, I think, actually also lends to the discretion, the fact that this was a proper use of discretion, that the trial court did not hinge its entire decision on this affidavit.
Can I wrap back on something that seemed as though you conceded and just make sure I understand why? I think the question was whether you agreed that the affidavit could not be admitted under the rules of evidence. And rules of evidence is always in DC. We don't have rules of evidence if you mean rules in the sense that the federal rules of evidence exist. I guess I'm wondering whether and I thought you said yes, they wouldn't be. And I was just wondering whether when you were saying that, you were either thinking uh, DC common law of evidence uh, should not have a catch-all exception, or if there were a catch-all exception, this would not fit within it. I know we haven't definitively adopted one, but we haven't foreclosed that either. So I'm just wondering about your concession.
It's a great and nuanced question, Your Honor. And no, I think we note in the briefing, we cite a federal court case, I think from, forget which circuit, was a circuit court case that applies the federal residual exception, hearsay exception in circumstances very similar to this. I think this would fall within the residual hearsay exception, given that this court has never formally recognized that as an exception in DC. I hesitate to say definitively that it would, that you know, I don't think for purposes of this hearing in this appeal, we don't need to reach that issue. That was the context in which I was responding to Judge Deal's question. I think that in terms of things that have been recognized by this court, the closest thing that would come is an unavailable witness. And I think this comes very close, but it falls short on the opportunity to cross-examine. It doesn't fall within that exception on that last prong. But no, on the residual hearsay exception, absolutely. And I think, yes, it was oh, it's definitely in our briefing. Yes, so here it is. It's a Third Circuit case, the Bowler-Udenholm case, where yes, even in a trial setting, where an attorney had died after making statements under oath, their statements were based on personal observations. It was in a context where the attorney would have anticipated being subject to cross-examination, and his testimony was at least partially corroborated by other admissible evidence. Based on those factors, the Third Circuit said that the residual hearsay exception would apply, that those were sufficient indicia of reliability. And so even if this court doesn't, as I don't think is necessary in this context, reach that question about in a trial setting whether that residual hearsay exception would apply, given that we're looking at a scenario where the trial court has a broad discretion, where the Rule 12 and this court in Thompson used permissive language about whether the rules of evidence would apply, that it's a proper exercise of discretion here to consider this particular piece of hearsay evidence.
I had a hard time following the briefs at some point about sort of what your theory of harmlessness is more of. So let me give you two options and tell me which one you think is your stronger, is your faster horse. So option one, forget about this affidavit. There's no question the trial court was going to find no deficiency anyway. So therefore its consideration was harmless. Option two, well, even if the trial court might have ruled otherwise on deficiency, had it not considered the affidavit, prejudice, prong two of Strickland was going to go against Mr. Sharperson, and this had no impact on that. So which theory of harm is sort of the one you're pressing more forcefully? Or, I mean, you could say both, but I'm just curious what your lead.
I think it is useful to distinguish between them. And I guess I also would say, and maybe this is why it wasn't as clear to Yarn in the briefing, that the first point I think is more significant to the extent that we're parsing these claims. The first point is maybe more relevant to specifically the consideration of the affidavit claim. The second point I think is more relevant to the broader question of the claim about inadequate preparation. That regardless of that affidavit or frankly any evidence of deficiency, we strongly submit that on this record, Mr. Sharperson has not identified any meaningful difference that there would have been in the trial evidence from any additional preparation by Mr. Long or Mr. Stovall, regardless of any allegations of deficiency, and that the simplest route to affirming the denial of that claim is on the prejudice prong. And so I will take that opportunity to segue, I guess, to that claim, which we did want to emphasize also that, you know, the theory of prejudice that Mr. Sharperson sort of presented, I think, for the first time in his reply brief and also again today, was about this idea that he would not have mistakenly denied making any inconsistent statements had he been prepared. I wanted to note that of the impeachments that were noted here, there's only one of them that he denied making a statement that he later had to acknowledge that he had made. And that was the one about whether or not he would, the reason why he went to get the car, whether it was because the women were in high heels or because he had planned to leave. He initially denied making that. The audio was played at that point. Of course, he acknowledged that he made it. He then did actually have an opportunity at trial to explain that he stood by his direct trial testimony. He didn't say, oh, now my memory is refreshed. He explained his jail call statement as being done in the height of emotion because he was hurt and upset. And neither party viewed that impeachment as significant enough to even mention it in closing argument. That was a very collateral issue. With regard to the other jail call inconsistency, or at least the government's theory that it was an inconsistency, Mr. Sharperson never agreed to the government's characterization of what he said on that jail call. It wasn't an issue of memory. The government characterized him telling his friend on his jail call that he was telling his friends, Ms. Wade and Mr. Andrews, to come to court and what to say. And he said, no, I never said that. Then they played the jail call and he said, yeah, no, that's not what I said. And he explained that what he was saying in his mind was that he was asking his lawyer to gather up witnesses to just tell what happened, that were witnesses that were helpful to him. So of course, I mean, the parties disputed and they argued in closing about the meaning of that jail call, but that didn't play out at trial as you forgot that you said this. It was a dispute about the characterization of that call. And again, just like with the first one, Mr. Sharperson he had an opportunity to explain his version of that call at trial, and he hasn't proffered or submitted in his 23-10 testimony anything else he would have said if he had had this, purported additional preparation on that point. And then the last point that the inconsistency that I wanted to bring up and that has been mentioned is this idea that in the interview with the police after his arrest, he said he called 311, not 911. Now, he actually wasn't confronted with that at trial, so he never denied making it. That was played during rebuttal. And of course, that was an inconsistency that the jury had an opportunity to consider. But Mr. Sharperson hasn't presented any argument as to how he would have avoided the jury considering that inconsistency. He didn't claim in the 23-10 proceedings.
He has one theory, which is he wouldn't have testified.
Well, so I can get to that in a second. I guess I can get to that in a second, Your Honor, because that's sort of an alternate universe, and that was his argument. That was his argument, or his testimony rather, in the 23-10 hearing. So I guess to just close the loop a little bit on the scenario where he does testify, he maintains that the testimony he gave at trial was the accurate testimony. He has not backed off on that. He didn't say in his 23-10 testimony, oh, if I'd watched my interview, I would have remembered that I actually called 311. So given that, and he's proffered no reconciliation or explanation as to how he would have reconciled those distinctions. Turning to Judge McLeese's point, though, the argument below was that he wouldn't have testified at all. I mean, we certainly maintain that in this scenario, I understand that appellant's counsel has pointed out what the defense viewed as, elements of the government's case that weren't airtight, but all of those elements were brought up at the trial. The jury was given the opportunity to consider them, and the jury ultimately credited NL's account, the corroboration from Ms. White, the account of Mr. Carey, the corroboration from the SANE nurse's examination of the medical injuries. And if they were given that same evidence absent any testimony about consent, I mean, I think in appellant's reply brief, they acknowledged that Mr. Sharperson's testimony about consent was critical to his defense. Appellant certainly hasn't shown a reasonable probability that he would have been acquitted if his own testimony, even with some of these impeachments, if his own testimony was completely absent from the case, that would have led to a reasonable probability of acquittal on these charges.
That's one way of imagining how that would have played out is assume that you credit his view that he wouldn't have testified. Could he show a reasonable probability of acquittal in that hypothetical world? That's one way of looking at it. Another way of looking at it is to question whether he actually has, established that he would not have testified had he been better prepared. And the trial court, I'm just curious how you read the trial court's order. The trial court's order refers to, on this general topic of lack of preparation, refers to Mr. Sharperson's testimony as self-serving and doesn't seem to be very persuaded by it. But I'm not sure there's a really clear statement by the trial court that the trial court is not crediting Mr. Sharperson's claim that had he been better prepared, he would not have testified. Do you read the trial court as effectively finding that or implicitly finding that, or do you think that's clear? We
do read it as it is not, again, I would acknowledge, not as clear as it could be. We do read that as an implicit credibility finding. The context in which that statement, I understand that something can be self-serving and still be credited, but the context in which that description was made was in contrasting the evidence that the court was relying on from the attorneys, from the affidavits and from Mr. Stovall's live testimony, which it set forth as clearly factual findings it was making that did happen. And Mr. Stovall's testimony, Mr. Sharperson's testimony was clearly inconsistent with that on some pretty fundamental points, even on things like him saying that there was never even a discussion about the fact that it was his right to decide whether to testify. There was no discussion at all about any downsides, the fact that he could be cross-examined or impeached. And so the trial court immediately then describes his testimony as self-serving, I think in the context of clearly indicating that it was not crediting his
I
testimony.
agree with what you're saying as far as it goes, but I'm not, because I do think you're right that with respect to preparation, the trial court kind of recounts the evidence suggesting there was preparation and then says, you know, Mr. Sharperson testified there wasn't, but that was self-serving. And so I think on the issue of preparation, it's fair to argue there's an implicit, it's not 100% clearly worded, but it's a pretty clearly implicit not crediting Mr. Sharperson's version about whether there was preparation or not. But that point doesn't really work as well on the somewhat related but distinct point about had other things, and maybe it's just logically presupposed, because if Mr. Sharperson's argument is if preparation that I claim didn't happen had happened, I wouldn't have testified. And if the trial court is saying, well, I'm finding that the preparation that you're claiming didn't happen did happen, and you did testify anyway, then maybe that's a longer chain of inferences, implicate, you know, implicit finding of credibility even on the latter point. But that it is a much less direct credibility determination if you think it is one at all on the discrete point of his claim that he wouldn't have testified.
We would submit the most reasonable way to interpret the failure, the lack of crediting his testimony in the context where this is addressing the inadequate preparation claim encompasses his testimony about choosing not to testify. That was testimony offered in support of that claim. I acknowledge that it requires an additional inferential step. To the extent the court's not agreeing to take that additional inferential step, we certainly maintain that even in a universe where that testimony were credited, that the standard for Strickland prejudice has not been shown on this record. Do see I'm out of time. If there are no further questions from the court, we rest on our briefing with respect to the other claims and ask that the Superior Court be affirmed. Thank you.
As I said, we'll give you your 3 minutes in rebuttal.
Thank you. Just have a few points. About the trial court's order, Your Honor, I think the government keep talking about implicit, and I'll just point the court to Colbert versus U.S. 2024 case, when Your Honor said, but in this discretionary sphere, we will not read tea leaves or prophesize about potential reasoning that the trial court did not in fact provide. So here we're just going, I mean, this is screaming for a remand. If we can't even understand what this trial court orders said or what was considered, at least remand it for that and direct the trial court to if not to consider the affidavit, Mr. Long's affidavits, or if it wants to, the trial court can go through analysis if it wants to try to consider it. As far as Thompson goes, the idea that it's just permissive language is just totally wrong. The procedural posture of that case, Judge Kravitz specifically said, I have no discretion to hear this, to look at this affidavit. He didn't say I could look at it, but I need to do it now. He said I have no discretion to look at it. And then on appeal, the appellant said that Judge Kravitz abused his discretion because he didn't exercise it because he thought he didn't have it. And then this court found that not just plain error has 4 prongs, as Your Honors know. One of them is error. They found no error. So if Judge Kravitz was wrong about him having discretion and thought he didn't have it, but he did have it, it was permissive, this court would have said Judge Kravitz erred because he thought he had no discretion. That's not what happened. So although the way
I take that line of thinking, but I guess if your way of looking at it is correct, then what we should have said in Thompson with respect to no error is the trial judge thought it had no discretion and had to exclude this. We agree that was correct. And did we say that?
it was Your Honor, not in those words, but the holding was what that was, because it was a plain error case. So the court had, of course, talk about other prongs, but the court said no error was made by the trial court. And I'll quote, this is.
I understand that.
Okay.
I mean, you may be making a point that the court in Thompson didn't appreciate. So I'm just trying to figure out what the court in Thompson understood itself to be holding. And I'm just wondering, when it said no error, did it say we recognize that the trial court in Thompson said these rules are binding on me. I have no authority to do anything other than apply them. And so, you know, the question is whether the trial judge was correct in thinking it had no discretion whatsoever. We agree with the trial court. It had no discretion, and therefore we find no error. Did we analyze it in that way and make that clear, or is it kind of an inference that that must have been what we thought, because that's what a correct analysis would have required the court to have held in order to reach that conclusion?
I mean, based on what I can quote the language, based on what was presented to the court, and I have a quote here, and what the court did, it's very clear to me that these 3 brilliant judges on that panel made the decision knowing what they were deciding. They knew, they weren't confused about what discretion was. They know what discretion is. They know what exercising it. And for instance, on appeal, Mr. Thompson argues that the court abused its discretion when it refused to consider the declaration. Mr. Thompson contends the Superior Court erroneously believed that its review of the evidence was limited to only the live testimony and exhibits admitted at the evidentiary hearing. That was affirmed. And then the court said, the trial court made no mistake of law. So all I'm saying is that there's no permissive anything in Thompson. Now, the other point about whether or not there's a catch-all, which we know there isn't yet, or it may not be, the case that the government cites, the circuit case, Elwood, is a civil case. And that judge, I looked at the case, that judge made very specific findings under the catch-all, which exists in federal court, cited the rule and explained all the reasons why this declaration, that position, that particular civil case should come in. In a 23-110 case where the trial court does not cite the catch-all, doesn't even say what she's using this for, says I can consider everything in the record. And Thompson was decided after this case happened. So perhaps, I mean,
Can I just ask one question? This is going to take you a little bit of a segue, but you know, the government invites us to sort of think about prejudice, or that is sort of an easier path. And the one thing about prejudice that I have a hard time getting past, and you haven't addressed it yet, so I wanted to get your take, is that Michael Carey seems like an extraordinarily compelling witness for the following reason. I appreciate he seems to be out on the corner with drugs, with an illegal gun. Those are reasons that people could discredit him. But he then drives this victim to, and I appreciate your client doesn't think she's a victim, he then drives the woman to her apartment complex, hangs around, talks to the cops, at some serious risk to his own well-being, given the gun that he admits that he has on him and has stashed away, declines an offer for a ride back. That seems so impossible to me to square with your client's theory that he got carjacked amidst a consensual encounter, that I guess I was just kind of curious. I guess I need to go back and read the closings more closely. What was sort of the defense line of, I don't know, about attack? What did the defense want the jury to think about Michael Carey, and why he acted as he did, if in fact the defense, if this was a consensual encounter and he was a carjacker?
Your Honor, that's a great question. It wasn't a very cogent theory as to why he wasn't credible. But Your Honor, I'm limited to, I can't put 12 points in my brief. I have to select points that are relevant that I think we can demonstrate if we had to deconstruct this case.
Oh, I don't mean as a theory of ineffective
No.
assistance. I just mean on prejudice. When I'm thinking about prejudice,
What I'm saying is that what this court said in Portillo and also in Truesdale recently is adequate preparation is everything for a trial counsel. So having the preparation to know, oh, this isn't going to work because X, Y, Z, or the client could take the stand, but then this will happen. When you have that kind of preparation and you see the case that way, so many things will happen differently. And that's why I read the standard for reversal and for prejudice. So it's not what the government's kind of implying, which is, well, we got to climb this mountain to show that this wouldn't have happened. We have to show something, but it's not on that level of even the preponderance level. So essentially, in that case, what the theory could have been easily is that this gentleman discovers something happening. The woman is embarrassed that she's having sex in a car, and then she says, "Oh, it wasn't consensual," and she's yelling out or something like that. Where the part where he thinks he heard it, he was smoking marijuana. He was wasn't thinking clearly, but he did do the right thing. He was a good Samaritan, but he doesn't know what really happened in that car. Only we do. Only that woman does, and only Mr. SHARPERSON. He has no right. He has a right to stay quiet and not testify. And the alleged lesions on her, contusions, are consistent with any normal bruise that anyone would get throughout the day. There's no scientific evidence to demonstrate that she was forced upon. And then she also made some statements about that she wasn't raped on the 911 call, some things like, to her mom. So essentially, it's not enough evidence to prove beyond a reasonable doubt. That would be kind of and if it were so compelling, I mean, the jury can acquit it on a couple of the counts. I don't know why, but all I'm saying is that essentially that could have been the theory without him testifying. Or if he testified, the theory could be a little bit different. But we don't know because there was a botched trial essentially with 5 different issues we have, all of which, I mean, the government can argue that custody is, they can argue that this case that they have, that custody is okay, but actually the court found in a case.
Counsel, I think you're over time, so if you want to sum up in a
Last thing I'll
sentence or
say.
two.
Yes, sir. I'll just say that This court found in a case called Young that applying Estelle that custody was prejudicial. I think it's something that has to be looked at in context and as one of the different levels of prejudice. Him being in custody could add to the mix of the prejudice here. So thank you, Your Honor. We ask the court to reverse and remand to the trial court. Thank you very much.
We thank both counsel for their arguments and their briefs, and the case is now submitted. Here now, the second case on this morning's calendar, second cases, two consolidated appeals. Burton as trustee of the EB Trust et al. Versus Chase Point Unit Owners Association et al., number 24 CV 1122, and a cross appeal, number 24 CV 1168, involving the same two parties. You may proceed when ready, counsel.
Morning, Your Honors. May it please the court. My name is Jake Schaller, and I represent the appellants. Evelyn Burton is trustee of the EB Trust, and Michael Burton is trustee of the EB Trust. I'd like to begin, Your Honors, with the words of Judge Carl Ross of the DC Superior Court. Judge Ross presided over a 3-day trial in this case, and after the parties provided their post-trial briefing, in his decision on the post-trial briefing, he wrote as follows. While the case involved statutory interpretation, at its core, the matter is premised on plaintiff's right to install an electric vehicle charging system in the exact manner plaintiffs preferred, even after being presented with an alternative method designed to accommodate all residents of the building. And that's exactly correct, Your Honors. This is a concise and accurate statement of what this case was about and what this case was about since it was filed.
Can I ask you, I apologize for potentially derailing your planned structure, but when you make that point, which is this case was centrally about the right to install a particular charging station, I start getting confused. Assume that is you're right about that, and that the trial court was correct in not granting you that relief. Then it gets very puzzling how you are a substantially prevailing party, because you're telling me that you lost the thing that the case was critically about. So I find a kind of a cross-cutting interaction between those points. So at some point, if you shed light on how you
Or, Your Honor, I'm happy to answer
I mean,
that.
I certainly get the point that if we were persuaded that the trial court erred in denying you equitable relief and it went back, either we ordered it ourselves or sent it back to the trial court, that ultimately, if that's the right way of looking at it, then maybe you would be a substantially prevailing party. But if we take for current, the assumption that the trial court was correct in denying that relief, then it does seem like it's an uphill battle for you to be a substantially prevailing party.
Sure, understand, Your Honor. And like you said, we will address the equitable relief piece of this. We believe that the court erred in not granting our equitable relief, and I will get into that. But I do believe that we're still the substantially prevailing party, because again, this case was about a denial of a right. This case, count 4, which appellants prevailed upon, was for violation of DC Code 42-1902.09. And that's a code provision that says if there's a violation of any of the condo documents, you have relief under this provision. The condo documents at issue in this case included the Chase Point Declaration, and section 6.2 C and D specifically provide these very broad easements that appellants took advantage of or sought to take advantage of when they were trying to install their electric car charging system. Chase Point denied the right to install this system despite the language of section 6.2 C and D of the declaration. Now, at trial, the jury found that Chase Point violated section 6.2 C and D. And in so finding, they found that our client had the right to install this system.
I don't see why that's right. So what's wrong with reading the jury's verdict the following way? The condo association was unreasonable in not providing some accommodation to permit your clients to install a charging station. They should have worked with them, through whatever vendors they wanted to allow this. And they violated, put aside the fact that the verdict seems quite inconsistent when it denies the contract breach claim and the statutory violation. Those two things seem coterminous to me. But what the jury might have thought, and we really can't tell from the verdict anything more than this, is yeah, you should have done something to work with them, but not that they should have been able to install whatever they wanted.
Well, I think if you look directly, Your Honor, at the language in the jury instructions, the jury instructions specifically request for plaintiffs to install an electric car charging system.
And, right, so
An electric car charging system.
not the exact one that they were proposing.
Well, but at the time the request was made, there was only one. This is well before any of the.
No, understood, but I mean, if I am trying to work with my condo association, I want to install a charger, and I say a charging station, I say to them, I want to install a charging station, and here's my plan. And the condo association says, A, your plan isn't very good. It has these concerns. We have these concerns about it. But B, in any event, we're just not letting people unilaterally install charging stations. A jury could respond to that by thinking, well, maybe the condo association had some good points about on the first topic, but they were, unreasonable in categorically refusing any ability to work with them to try to get a suitable and appropriate solution to the problem. So I don't see that there's anything intrinsic in the way the issue got teed up or the way the jury instructions were worded to say that, leaving aside the possible inconsistency, to say that the verdict must reflect the idea that the particular plan proposed by your client should have been given a green light without any modification or concerns by the condo association. So but I think I might have interrupted you when you were referring to the jury instruction, and I kind of zeroed in on the word or some equivalent of it rather than a definite article. But so if you have other language in the jury instruction that you think aids your point, I don't mean to derail you from trying to refer to it.
Thank you, Your Honor. The jury instruction did request the right to install. And again, if you look at what I began with, Your Honor, what Judge Ross, how he summed up this case. And if you look at the language that was used throughout the case and throughout the complaint, the request for relief in count 1, the declaratory judgment count, sought that appellants, quote, have the right to install, unquote, an electric charging system, quote, according to the plan plaintiffs have presented.
Yeah, no, you definitely requested that relief, but there's no jury verdict saying that they violated that right. That declaratory judgment request was one that went to the judge and it didn't go to the jury. So, I mean, I take your point that is what you wanted and that was the core, but that actually seems to cut against your claim for attorney's fees, unless you're right on that the court had to grant you equitable relief. But I don't see why you asking for it means that the jury found that.
Well, I think if you look at the jury instruction, again, Chase, for the Burtons to win on count 4, they had to prove that Chase Point, quote, violated section 6.2C and 6.2D of the Chase Point Declaration by refusing to allow plaintiffs to install an electric vehicle charging system.
Yeah,
So
but we're going around in circles, though. I mean, I think we just explored that one plausible interpretation of that is their blanket refusal to let you install any charging station is something that the jury might have found was unreasonable. But the jury did not say, and they should have allowed you to install this specific one. That those are different things. And I don't know why. Pointing me back to that same language just runs back into the exact same problem. I don't see what about that language says this specific charging station.
Well, I think it was throughout the case, Your Honor. This was what was discussed. The case.
Sure, it's certainly what you guys wanted. I just don't know why. If I'm a juror back there and this is the instruction that I have, why couldn't I, no matter what you guys argued, why wouldn't one rational thing for a juror to say be, look, guys, I think this condo association was being quite unreasonable for not letting them install anything. Now, what they actually wanted might have had all sorts of problems with it. And, the condo association certainly could have put restrictions and limitations, require them to work with approved vendors, knew their grid or what have you. But the blanket refusal was unreasonable, so verdict for your client. Why is that an implausible theory of what a juror might have thought?
Well, I think, Your Honor, part of this is the evidence presented at trial included the condo's plan that they presented. So Rule S, which the Chase Point Unit Owners Association has kind of proffered as, and indeed the trial court proffered as a reason why our request for injunctive relief is moot, because now there's this system that's been installed. That was all presented to the jury. There was testimony about Rule S. There was evidence about Rule S. The jury had in their hands
But before we talk more about Rule S, can you give me the timeline? I mean, why couldn't a juror have thought the denials a couple of years ago were unreasonable, and now the condo association under Rule S has a perfectly acceptable program for going forward?
because the harm was in 2019 when Ms. Burton made her initial request.
Right.
So the condo association retroactively post hoc coming up with legislation to take away a right that she had in 2019. That's just simply not what the case was about and what the jury was looking at. They attempted with this legislation to kind of have a do-over. These Rule S basically narrows the scope of these easements. And in section 6.8 of the declaration, there is language that says, okay, if you would like to have rules and regulations on these easements, the condo association has the ability to look at these easements and narrow the scope of them. That's what the condo association did. But in so doing, that admits that Ms. Burton had the right to do this her way prior to Rule S. And
I'm sorry, why does it admit that? I mean, the condo association, I mean, the jury ended up, I think, agreeing with you in part, although in a verdict that's inconsistent, so it's hard to fully understand the jury's thinking, but, or at least seems to me inconsistent. Taking the part of the verdict that's favorable to your client, agreed with you in part, and it might well be that their understanding was, well, now Rule S is a good solution going forward, and so we're not, that's why we're only awarding $4,000 in damages rather than more. And but there was a time when the condo association was unreasonably saying can't do anything. That the condo association, maybe under the influence of this lawsuit, decided, well, we don't have clear rules about when you can or can't install electric charging stations, and now we're in litigation about it. Let's have a rule that lays out our procedures. I don't know why that admits that they were required to do anything before then. It just could suggest that there's a problem that's arisen that they want to address in the document so that they won't have litigation about it. So I'm not sure why it would be viewed as an admission reasonably.
because, Your Honor, if Ms. Burton, if the appellants had the right prior to Rule S, and that is really what the jury found, did we have the right to install an electric car charging system pursuant to section 6.2 C and D? When they had to come back and retroactively fix that, when they had to tighten up the easements, that's saying that there was an issue here. If there was no issue with the easements being so broad, there was no reason to have Rule S to close those up. Now, I can understand having Rule S to talk about how you implement this system, but it specifically says that only the association can install electric car charging systems. It can't be any of the residents of Chase Point. So, Your Honor, I see I'm kind of running low on time.
I guess I am interested in hearing from you on two things, at least briefly, that you haven't gotten to yet. One is your assertion that you were entitled to equitable relief, and then the other is the kind of fee piece of it. So on the equitable relief component of it, if the jury's verdict, well, first of all, can I ask you, it's come up in the comments of at least two of us already a couple of times. Do you agree that the jury's verdict is inconsistent, that it doesn't make logical sense for the jury to have found a statutory violation that seems predicated on a violation of contractual provisions, but not to have found a breach of contract relating to those exact same provisions?
I think on the surface, Your Honor, it does seem inconsistent, but there's a very easy way to harmonize it. During deliberation, the jury came back with a question about the instructions on the breach of contract claim. And within the breach of contract claim, there was language about the duty of good faith and fair dealing. Was there a good faith element? And it seems clear, at least to us, that what the jury asked, do we read these together? And the answer was yes. But I think the jury interpreted that as, in order to have a breach of contract, you also must have bad faith. And I think that perfectly harmonizes this because it shows that the statutory violation, it was just, did you violate the statute? Yes. Breach of contract, we had this added element of bad faith. So yes, you breached it, but there was no bad faith. So I think that's how you harmonize those two decisions.
So thank you. On the, which in sum is, you think the jury might have misunderstood instructions that were given to it relating to the contract part of it, the case. Is that a fair summary of what you're saying?
That's a fair summary.
I understand your argument about the trial court being incorrect in thinking the issue was moot because your complaint, properly understood, requested, and asserted a right to install a particular system, and that's not moot. The Rule S doesn't authorize you to do that. I take that line of thinking, but what's your argument about why you think the trial court was obliged to grant you equitable relief? The trial court, in addition to saying that the case was moot, a ruling that I have my doubts about for the reasons you identify, the trial court then went on and said some things that were in the nature of, well, the relying on evidence at the trial that I know dispute, that actually what you were planning to impose would create safety concerns, and so said some things about why it just didn't think, as a matter of its exercising its authority to grant or not grant, or I don't know if the trial court was conceptualizing it this way, but the trial court said some things that would be the kind of thing that you might say if you were explaining why you weren't going to grant equitable relief. And I know you dispute the trial court's view of the evidence in the sense that you don't agree with the factual points the trial court is raising. But are you saying that those factual comments are clearly erroneous, or what's your reason to think that the trial court didn't give adequate reasons for declining to grant equitable or declaratory relief?
Sure, Your Honor. I think the trial court had three reasons for denying the equitable relief. One was that it was moot because of Rule S. We've gone over that a lot. The other was the language of that was used by within the request for relief, the jury instructions. We've gone over that as well. There was also this issue of the purported safety, and I do believe that was clearly erroneous. Our expert witness, there was this issue of, okay, you're breaching a firewall. Our expert witness said this was not, in fact, a firewall. And on top of that, there's actually a gap in this wall where you can run your conduit through. Not only that, appellee's expert also weighed in at trial about the fact that this system would work. It could work in tandem with the system that Chase Point was proposing. So I think for all these reasons, this was not the right reason to deny equitable relief. And the court is bound by the jury's factual findings. And if the jury found that Chase Point violated Section 6.2 C and D by refusing to allow us to install our electric car charging system, the judge is bound by that.
Right, and well, I guess that raises two questions. One we've already discussed, both of which we've discussed in a different context. One is you said if the jury found that you were entitled to install your exact system, and there's a question about whether the jury found that. And the other question is, leaving us, if it's hard to tell that the jury found that one way or another because the verdicts are inconsistent. If we're unpersuaded by your view about how to reconcile them, then that also is a complicating factor about whether the trial, I'm not sure what the trial court is bound by. If the logic of verdict A and verdict B means is incompatible, I'm not sure what the findings inferentially are. So those are two complications with that line of thinking.
Sure, I understand that, Your Honor. I think I would go back to just, I feel like I've made the point a few times, so I don't want to belabor the point, but the language of the trial court instructions was about installing this system. And the fact that they were denied that right, that was why the jury gave appellants the victory on this count 4. And so again, the trial judge is bound to follow that. And we cited cases, the Kolstad case, the Hubbard case. Superior Court is required to follow the jury's factual findings.
I don't think that's
Yeah.
the disputed point.
Okay.
The issue is what the findings were. Let's shifting over briefly. I know you're over time, but on the fee side of the case, can you tell me, do you agree with the trial court? The way I read the trial court's ruling, subject to, what you persuade me otherwise, is the trial court said, the statute says substantially prevailing, but that really isn't adding anything. I'm going to treat this as though that means nothing different than prevailing, and I'm going to apply the law that would govern if the word were if the phrase were prevailing instead of being substantially prevailing. Do you read the trial court's decision that way? First of all, do you agree that that's
Yes, that's how.
and do you think that's legally correct? Do you think that the right way of understanding the phrase substantially prevailing is that the word substantially adds nothing, and that instead we should just understand it by interpreting it in light of our law about what the word prevailing means in fee statutes?
Sure. I think it was a fair way to look at this particular case, but there's a few things here.
Well, can I just, before you go too far, I'm asking you like a statutory interpretation question, so I don't think the answer to that will turn on this case in its circumstances. Now, maybe you mean for this statute as opposed to others, but I just want to, again, just to clarify what my question is about
Sure.
about how should we understand those words in this statute in all cases to which the statute applies?
Understand, Your Honor. I obviously, if you add a word to a statute, especially a modifying word like substantially, then yes, it changes the statute. Here, however, I think there's a couple things. Number one, it's lowered the standard. So if we prevailed, we certainly substantially prevailed, and we got into the etymology of the words and some.
Well, can I ask you why you think that? I mean, if that were true, if it were clear that really the trial court required that you have 51% success, and that's what prevailing would mean, and substantially prevail opens up the idea that 37% success would be enough too, then if the trial court got that wrong, it didn't affect the trial court's decision here except adversely to you, because a fortiori, if the trial court thought you succeeded 51%, then it must have thought 37% would do, and those are, I'm making those numbers up. And but I guess the word substantially is a very ambiguous term, and it can mean a lot of different things. And for sure, sometimes it means more than de minimis or something like that. And if that was the meaning, it's a burden lessening term. If you think substantially prevailing means prevailed at least in a non-trivial way, more than de minimis, then you'd be right that that shouldn't be an outcome affecting problem here. But it doesn't always mean that. Sometimes it means like a lot. And so sometimes if you think prevailing means you got to be at least 51 and substantially means is additive rather than subtractive, then, it might be, you'd have to be 67 or, 73% success. And although we don't have a lot of law about what that phrase means, around the country, courts take a variety of views about it in a variety of statutes, some taking it to be subtractive in the way you're describing, and some more think of it as an intensifying term, meaning it's not enough that you prevailed, you have to really have prevailed. And so I understand from what you just said that your view is the trial court really wasn't right to equate them. The trial court should have thought it was lessening, and therefore so we could clarify that, but that wouldn't change the outcome that you're a substantially prevailing party. Is that your view?
That's correct, Your Honor. And I think it's especially true in this case, where, as we've discussed in the briefs, and this goes to why we appealed the reduction, just giving us this. I think this question of substantially prevailing really kind of dovetails with a lot of just the general attorney's fees case law, and looking at, like Hensley versus Eckerhard, and the idea of you look at, did you lose on unrelated claims? And as we pointed out throughout our papers, all of these claims in this case were about this one issue that I started with, what Judge Ross said. There were different causes of action. there was declaratory judgment, there was breach of fiduciary duty, there were the contract, the statute, we even had a intentional interference with property, but all of these, with the exception of the books and records claim, which was, it was mooted very early on just because of discovery. All of these claims were on this one central issue. And so the question of substantially prevailing is not quite as important in a case like this. Now, if you had a case, let's say we had a case where a company fires someone and there's a claim for breach of the employment agreement because he wasn't showing up to work on time. Then there was a harassment claim because he was harassing somebody. And then there was a trade secret claim because he was leaking trade secrets to competitors. And then there was he breached the non-compete agreement because after he left, he started taking a bunch of employees. He tried to get them to come with him. That's 4 separate claims based on 4 different sets of facts. Here, while we had different causes of action, it was all the same facts and was all trying to get to this one point.
Well, let's go back to the earlier discussion we had because I want to know how it affects this argument. Let's separate out 2 potential views of your claim. Claim 1, the condo association breached our contract, violated the statute by not allowing us to put in some charging station. Maybe not the one we wanted, but something. They just shot us down entirely. That's one version of your claim. And the other one is we should have been able to put in the charging station as we wanted to, and they breached our contract that way. You think you substantially prevailed under either view?
Yes.
Now, here's why I ask, because earlier you were telling me really this whole case was about this second thing that we wanted to put in our own, and that's what we were arguing. And if the jury didn't find that, why do you think you still substantially prevailed? It sounds to me like you lost the thing that you have been telling me all day, that, throughout this argument, not all day, but, for the last 30 minutes or so, was the gestalt of this case.
Well, I think there's a fine distinction, Your Honor, and that distinction is we were trying to protect our right under the condo documents to install this. So yes, we haven't gotten this relief yet. We believe we should get it. We believe, for all the reasons I talked about, we were entitled to that right, and the court erred by not allowing us to install our system. But the case was really about the right to do that. And the jury found.
So what's the right to put in a charging station, or the right to put in your preferred charging station?
Put in our preferred charging station.
Okay, so but if I don't read the jury as having ruled for you on that, and if you end up not getting that type of equitable relief, why do you still think you have substantially prevailed?
Because this was the one issue in the case. And if we don't get the equitable relief, that's what we wanted, and that's part of the relief. But look, at the end of the day, it's who won this issue. And the issue was, were our rights violated? Did the condo association violate the declaration? So,
Seems to be really at bottom of you that if you want anything, you substantially prevailed, or at least if you want anything that's non-trivial. Is that sort of what the way you would understand what substantially prevailed means? Is, you didn't get everything you wanted, but you got something that's not negligible, and therefore you should be the substantially prevailing party.
Yes, Your Honor. Yes.
You don't think you don't think it is necessary that you won the most important thing you wanted, or half of your claims, or any of that. As long as you won something that's non-trivial, then the trial court should treat you as a substantially prevailing party. Can I ask you, that seems a little, because the statute is now symmetrical, the fees, so the condo association could also get fees if it won. And if the condo association says in its cross appeal, for example, okay, well, let's say that that's the right way of looking at it. All you have to do is win some non-negligible things. Well, they won some non-negligible things. Assuming that the equitable relief is not ultimately granted to you, or given that right now it hasn't been, wouldn't they say, well, why aren't we a substantially prevailing party? The whole issue about this, the main issue, as my opponent frames it, is did they have a right to install this exact thing? And they don't have that right. They've not been allowed to do that. And so they lost the main thing they wanted. Why wouldn't they be a substantially prevailing party? Can we have 2 substantially prevailing parties? Because again, if prevailing means you won more than half, then on one side of the caption, there can't be prevailing parties multiple on opposite sides of the caption. Whereas if it means you win something non-negligible, then in theory, both sides could be viewed from a practical point of view as having won something pretty significant. And can they both be substantially prevailing parties? And then do you offset the awards for each of them, or how does that work?
Well, I think, Your Honor, if you look at actually the case that the court cited, I think it was Knight versus Georgetown case, they were relying on that case for this standard for mixed verdicts and saying that the defense has to win. The plaintiff can be granted no relief for the defendant to be the prevailing party.
And that's
So-
true under certain prevailing party statutes, but if substantially prevailing modifies that and weakens
then
it,
that
that seems different.
Right, that lowers it, but I think in most of the cases that we've briefed in our appellate papers, these cases typically have cross claims. They're counterclaims from the association. So now if we had the association making claims against Ms. Burton for whatever it is, whatever condo violation she might have had, then I think that's where the substantially prevailing issue becomes more prevalent. We cited in our papers that this is kind of a negligible, there's the Seventh Circuit case that we cited saying that they don't see much difference between substantially prevailing and prevailing. We think that's especially the case here when there's just this one issue. And I understand what Your Honor's saying about maybe there's a mix, but the bottom line is we had the victory on this one issue on count 4. I equate it to a football game. You might lose, you might have the time of possession, you might win the turnover battle, you might have more rushing yards, but what was the score at the end of the game? And we believe the score was us winning this count and that winning the main issue in the case.
Thank you, Counsel. You're well over time. We'll give you a minute or two in rebuttal.
Okay, thank you, Your Honor.
Good morning. Miriam Tadros Remy here on behalf of the appellee and cross appellant Chase Point Unit Owners Association. I think the court's absolutely right. There is no way to say that the dominant issue in this case is getting the car charger that plaintiff had specifically wanted, not getting that, and then claiming to be a substantially prevailing party, which I will address that standard in a few minutes. But first, going to the issue of declaratory judgment and the denial of the injunction. The question is, did the trial court abuse its discretion? The answer is clearly no. First, going to the specific jury instruction number 2, it said that the plaintiffs, by refusing to allow plaintiffs to install an electric vehicle charging system, that was the language, that there was a violation of the statute. There was nothing to indicate that the jury came back and said that the plaintiff would have been entitled to install her particular system. Now, I know that the appellant relies upon the Hubbard case.
Can I, before we go too far afield, I thought you were about to tell me why the trial. So one issue I have with the trial court's ruling denying declaratory equitable relief is that its principal basis for denying it was mootness. Saying, well, this request for relief is moot because now you have Rule S and there's a path to installing an electric charging station. Do you agree with that?
I think the trial court said that, yes, I do agree with it. The trial court also had the backup reasoning of the evidence before it was this could have been presenting a significant safety issue.
But the argument that you are making right now would seem inconsistent with the mootness ruling because you're saying really they wanted to install this specific station. They haven't been granted relief. They still want it. Judge, give us that. And the judge said, no, that's moot. Doesn't seem moot. It seems like they still want it, and it hasn't happened. Rule S hasn't given it to them. That's a different path to installing a charging station. So why is their request for declaratory relief moot?
Because of the enactment of Rule S in 2022, there was a mechanism by which they could achieve having an electric charging system.
Yeah, but their request for declaratory relief was not let us have an electric charging station. It was let us install the thing that we want as we want it. Why is that request moot?
Because there, again, the court found that it was the enactment of Rule S, but the court also would have found that the safety issues prevented them from having the relief that they sought.
So that's not a mootness concern though either. I mean, if I'm not going to give them their relief because I'm concerned about safety, is not a mootness reasoning. That is a, you don't get it, not a, and you don't get it because you've already gotten it. That's a mootness reasoning.
So the court found that it would be engaging in a purely academic exercise at that point, because at that point, 2 years after the enactment of Rule S, there was a mechanism by which plaintiffs could have had what they wanted at that time, but they had to go through the established procedure in the association.
If
So
they-
this wasn't
well,
back in.
I still have two questions. They don't want to go through those procedures. So they want to use their guy the way they want to do it. And why is that request moot?
Because the court, I think what the court had found was that there was a procedure by which they could go about this. That was really the only procedure that's allowed in the condominium documents, which were not challenged. There was nothing filed by Ms. Burton or Mr. Burton challenging the validity of Rule S.
When you say nothing filed, I had the impression that they did introduce evidence at trial intending to, or that they characterize as trying to present to the jury or to the judge as a decision maker down the road on the record that was being created at the trial, for the idea that Rule S was not an adequate solution, that it had problems of various kinds and was not consistent with what they thought they should be entitled to do, or is that not correct?
They did do that. What I'm referring to is the statutory mechanism by which they could file a claim declaring, asking the court to declare Rule S invalid for whatever reason. They did present evidence at trial that she thought that this was too cumbersome. She liked
Or
her
you
specific.
think they were required, if they have filed an action at a time when Rule S doesn't exist, saying we have a legal right under the documents that exist at the time, that we're filing to install this particular system, and then Rule S comes in and then they don't maybe file anything further about Rule S. I don't know what all got filed in the trial court, I guess, so I don't know what documents got filed. But then at trial, they make the argument that I know there's this Rule S, but Rule S doesn't defeat our claim because Rule S is, not adequate for a variety of reasons, and therefore it shouldn't prevent our getting relief from the jury on our legal claims, and then maybe later argue to the judge it shouldn't prevent us from getting relief. You think they were required to do more than that?
Well, I think they can say we don't like Rule S, but Rule S was in existence. No court had found that Rule S was
I
invalid,
think
that it wasn't
but
properly.
the question is whether
enacted.
the evidence they're introducing at the trial about what their claim that they have a legal right, if a part of it is directed at saying, to the extent the landlords are trying to say that it limits our damages or otherwise defeats or undermines our claim for equitable relief that we're later going to be pressing. If they want to rely on this Rule S, by the way, Judge, we're telling you and we're contesting right now in this proceeding, Rule S is not an adequate, it's not an appropriate answer to the question. It doesn't defeat our claim, and here's our evidence about why. Do you think they would need to do more than that somehow, or could they do
I
it in
think-
that manner?
Well, no, I think that you can't say that Rule S is invalid or inapplicable at that point. We have to look at Rule S and say, does it apply to you? Instead of saying Rule S is wholly invalid. Had they filed a separate challenge, for instance, saying that it wasn't duly adopted or something like that. But they are stuck with the language of Rule S. It may be inconvenient, but that's like saying, well, we don't like, Section 3 of the Declaration because I find that inconvenient. So looking through the framework of Rule S, the trial court presumably thought, well, she's entitled to a charging station. I'm not going to set aside the jury verdict, even though obviously we thought it was inconsistent and moved to set it aside and for a new trial. The court said, well, she has a mechanism by which she can do this. I am not obligated to give her the specific mechanism. And the point that the appellant had made, citing the Hubbard case, was the jury found that she was entitled to this specific system because that's what the jury said. In Hubbard, the jury had actually answered factual questions. One being, do you find the defendants, Dr. Chidel, Weiner, Boyle, and Associates, were negligent? Do you find that their negligence was a proximate cause of the injury? The jury answered yes to both of those. The jury made no such finding here. All the jury did was rule for Ms. Burton and Mr. Burton on the statutory claim and awarded them $4,000. So there's no argument that the trial court did not follow the jury's instruction. Going to the other issue, the court did give us backup reasoning. There was a safety issue. And to walk the court through a little bit of the factual background, there was only one application that was submitted by the appellants, and that was attaching Jason Zawatsky of Half Power's proposal. That proposal specifically stated that they would have to penetrate through a wall and then put in fireproofing. Jan Preston, who is here today, wrote on behalf of the association saying that this is a safety concern, and we also couldn't duplicate this for every other owner that wanted a system. There was never a second application that was submitted. The only application that was submitted and before the board in making this determination was the one that attached the Half Power proposal. Mr. Bowles, the expert proffered by the Burtons, may have said, okay, there's a different way to do this several years down the road, but no new application was ever submitted. So it doesn't matter what he found later on, that issue was never before the board. So even if you do not believe that this was mooted, there is no abuse of discretion in the trial court finding that this was going to create safety issues. And implicitly,
I'll confess that I have not read the competing testimony on this. What appellant's counsel says is that's clearly erroneous. There was in fact a passage, there was a pass-through in this firewall where you could run cords and you don't need to breach it at all. And the testimony was clear about that. So this finding would have been clearly erroneous. I don't know. I haven't read the testimony, but do you have a reaction to that?
I spent a lot of time rereading Ms. Burton's testimony, and I had asked, and this had come up throughout the trial, of was there ever another application that was submitted to the board?
Oh, no, I'm not, I don't think I'm asking that. And I don't think the answer is going to be in Ms. Burton's testimony. I think their representation is the wall that is being claimed that they would have to breach and patch up, in fact, has an opening in it that you can run these cords through, and that means they didn't have to breach it at all. So this was not going to be an issue. And if you look at the competing, if you look at their, I assume their electrician, his testimony, that there's nothing to contradict that. And so there was no safety issue if you look at the testimony.
But the question isn't whether there was a safety issue later on. It's did the board err in finding that there was a safety issue when it received the application? Because at its core, what the case is about is saying that the board was unreasonable and violated the Burton's rights by denying the application. The board is not required to rewrite the application. The board's not required to revisit the application.
Sorry, did the board, so now I guess I might be a little bit confused on the facts. I thought the answer to their request was, no, we're not accepting, we're not approving requests to install charging stations, period. I did not understand that it was, we'll review it, and we've reviewed it, but there's safety issues, so therefore rejected, which
So,
maybe there's both. But I had thought the first pass was, we're not doing this. We're not approving individual applications. We're considering it as a board and looking for something global, not one-offs.
the board actually had a few points that it made in its August 19th, 2019 correspondence.
Okay.
One was that they were having a global solution, and so it wasn't appropriate to do this. It couldn't be replicated for everybody else. They certainly don't want owners in the electrical room taking up space with the load management device, because it wasn't just you need to run a wire. They were installing things in the electrical room, which is a common element. But Ms. Preston had written, please note that among other things, your application proposed to penetrate the firewall surrounding the electrical systems room with fireproofing. As a matter of principle, for safety and structural reasons, we are not comfortable with approving an approach whereby each owner would have the same expectations that they could reach that firewall. We are talking about potentially tens of cuts if your proposed approach was pursued by all interested in the same amenity. She goes on to state that the proposal also requires wall space for installation of a load limiting device. And that room cannot accommodate all of these devices. If other owners were interested, at that point, they knew other owners were also interested in the amenity, and they were trying to get the amenity for Chase Point.
Take your point. I understand. I understand. I think your line of thinking, which is whatever the evidence may have been about what others' proposals would have been able to do, you think that the focus ought to have been uh, the exact proposal that was submitted, and that contemplated penetrating a firewall. And the trial court does say in its ruling, plaintiff's proposed solution. And so your argument is, like, if I understand it, even if later at trial, their expert comes in and says, well, actually, we could have done something different. We could have not penetrated a firewall, and that might have worked, that maybe that would work and address your concerns. That isn't what was originally proposed. And I guess if that's right, maybe it's also what your opponent isn't asking for. I mean, if there really are equitably saying what we wanted from the jury and what we think we got from the jury and what we wanted the judge to replicate is the exact proposal that we submitted, then maybe I get your point. But I just have a factual question, which I don't remember the trial evidence well enough to know. I mean, do you agree that there was some testimony that at trial where your opponents were suggesting there were other ways of solving the problem that would not have required penetrating a firewall? Because I do recall there was testimony about could go through other holes and wouldn't have to penetrate things.
Yes, Mr. Bally had testified to that, but that issue was not before the association. There's no explanation for why they could have submitted another proposal when they realized that they didn't have to penetrate a firewall. No additional application or proposal was submitted by Ms. Burton. The board has no obligation to rewrite the existing proposal. It certainly has no obligation to do that years later. It provided a denial, which interestingly, the board told her exactly how they would rule on the request prior to her purchase of the unit. Mr. Steinwurzel, then president of the association, responding, saying, we're not going to be able to approve your request at this time. Ms. Burton testified that she did not follow up to figure out what at this time meant and just thought that the proposal that was being done by the association through PEG was taking too long, in spite of the fact that all of this was happening also in 2020 with the pandemic and the shutdown of the building.
You're also over time, but I am interested in hearing on the fee side of the case from you. So could you start by just, as I think you advertised you plan to do at some point, laying out what your view is about what the phrase substantially prevailed means?
Yes, substantially prevailing would mean that we won more than we lost. What the appellants have asked the court to do is effectively
How is that
strike
different
out.
from prevailing in your view? Isn't that what prevailing means or not really?
Prevailing means obtaining any relief whatsoever. So had the standard been prevailing party, could arguably be a prevailing party. There is a distinction between prevailing and substantially prevailing that's been found in many of the cases that have been cited. And in fact, the Burton case, which was, I think, cited by the parties, with counterclaims, the plaintiff got a net recovery of $566 and said, well, that is not a substantially prevailing party.
Can I ask you a question about, I get hung up on the terms about like winning and losing. And if I'm a plaintiff and I am trying to get, $1 million, that's my request for damages, and I get 100,000 at the end of the day, I guess, I mean, depending on how you are defining victory and defeat, I could think, well, I'm the plaintiff, I got $100,000, I lost nothing. What's the benchmark for how you measure what a victory or a defeat is? Whereas, if I'm the defendant and I think, wow, this is a game where I could lose $1 million if it went really badly, and I ended up losing only 100,000, so I won 900,000, and I won a net of $900,000 against the world where my opponent got everything my opponent was seeking. What's the benchmark for how you determine how much somebody won and how much somebody lost, where fees are available both to plaintiffs and to defendants? I guess I'm not quite sure whether you won anything or you just didn't lose as much as you might have?
Well, I think that the trial court's job would be to examine the matter holistically, not just to say you won something, therefore you are a substantially prevailing party. And I think if I may read from the Root 777 case, thus there can be little doubt that the defendants was awarded summary judgment on the vast majorities of the significant issues in dispute. Defendant is not barred from a fee award simply because defendant did not prevail on every issue. The result comports with the common sense intuition that a substantially prevailing party need not be a completely prevailing party. Indeed, to say the defendant did not substantially prevail in this dispute is to deny that the San Francisco Giants won the 2014 World Series because they only won 4 of the 7 games. So when we look here, what
Yeah,
did
I
the
mean,
play-
on the baseball analogy, at the end of the World Series, all the Giants get to wear rings and get money and all that. I mean, at the end of this litigation, you were down $4,000 and got nothing in your favor from what you had before. So one way of looking at it is you won 0. You just lost less than you might have if your opponent had won more. So why is that the wrong way of looking at it?
Because that analysis would require us to have asserted a counterclaim and won something. And the statute doesn't require that we file a counterclaim. One way to look at it is we have to pay them $4,000. I think more holistic approach would say we got 2 claims dismissed for breach of fiduciary duty against 2 board members, which is very significant. And the principal issue in this case is the installation of a specific system as designed by Half Power. And today the association does not have a load management device in its electrical room. It's not running wiring, and it doesn't have installation of that particular system. So we won. We won, I would say, 6.75 of the 7 claims. They had, I think, requested by the time of trial, $16,000 in damages. But even winning the 6 claims, we won the main issue in this case, in that Ms. Burton and Mr. Burton cannot install their specific system. So when we look at it holistically, we are clearly the prevailing party. And in fact, that is the basis of the appeal, is that they lost the one thing that they wanted. We wouldn't be arguing that today had the association not been the substantially prevailing party.
In other contexts, like under the DC Human Rights Act, it's often looked at on an issue-by-issue basis as opposed to entirely collectively. And I granted there are specific differences there too statutorily, but they look at it more as a way of tempering when they award the actual fees beyond that. Is there a reason why the trial court couldn't look at it and you substantially prevailed on this issue, you did not on this issue, and then take that entirely into the balancing on the attorney's fees portion of it?
Could the court have looked at substantially prevailing on every issue? I think we look at the statute itself and it says in an action, it doesn't say by issue, then you are the substantially prevailing party. So I think that we're just limited to the language in the statute itself. And I will note that we have cited the legislative history, and the intent of that statute was in cases where there's a minor win by someone, the association isn't bearing all of these fees. And that's exactly what we have here. The association has been in this litigation almost 6 years. They've expended fees paid for by insurance and they're deductible, but they shouldn't have to then pay at that time of trial $621,000 in fees to an owner that only succeeded in recovering $4,000. Would the court like me to address the reasonableness of the fees? I understand I'm over my time.
If you want to address it in a sentence or two, feel free.
The trial court did not err. The one thing I do want to point out, that it was the burden of the appellants to show that these claims were related. There was no showing in their motion. There was nothing in the reply indicating the relatedness of the claims. And so the court said, this is not a complex case, which is true. We're talking about a couple of provisions in a contract and a statute. And then the court said they did nothing to separate out the entries for each claim. And if the court looks at the affidavit, it is apparent that it was all just intertwined, and it was left to the trial court to try to figure this out. And that was not the trial court's burden. It was the appellant's burden, and they failed to meet that burden.
Actually, let me ask you a question about that, just to make sure I understand your point about what arguments were made when and what details were developed or not when. So they file a fee application, which I gather doesn't, when it's reciting hours that were worked, try to allocate them among the various claims and say, it's true, we won only, one of these claims, but all of, here are all the hours that relate to the claim that we won. They didn't do that in their fee application. And when you filed your opposition, is that a point that you made?
We did
Is that
not
a-
raise that point. We raised the reasonableness of the fees, but that was also not addressed later on. It
I'm
was.
just wondering, because
Yes.
if you had raised it and then in their reply, they hadn't said, oh, well, now that they're making that point, we are allocating, we can answer that argument, then it would be worse for them than if that's a point you didn't really raise before the trial court ruled.
It was not, but, and the court had noted on page 14 of its opinion that the requested attorney's fees are not broken down by claim. And the court finds that 1/7 of the reduced billed amount based on prevailing on one of 7 claims to be a reasonable award. It was not the job of the trial court to say, well, the contract claim is related. We would argue that obviously the breach of fiduciary duty claims should be excluded. So should the books and records, the intentional interference with property rights. But those were arguments that were never made before.
Can I just take you to the statutory language real quick? And I just want to understand how your view jibes with it. So the substantially prevailing party in an action brought by a unit owners association against a unit owner or by a unit or vice versa shall be entitled to recover reasonable attorney's fees and costs expended in the matter. Not as to the claim. I mean, do you read that as being sort of only on the particular claim?
No, I do not.
It's case wide, right?
It is case wide, so I don't think we have to engage in it. But the first step in that statute is to find there a substantially prevailing party.
Sure. No, I
Yeah.
understand. I thought, I'm sorry, I was speaking only to the calculation.
Yeah.
So I guess if let's say that it was undisputed that somebody was a substantially prevailing party, but they expended some hours on relatively discrete claims as to which they did not succeed. The question is whether the trial court is obliged to take that into account in assessing the reasonable amount of the overall fee award. And the words in the action don't point in that direction. And I don't think you said the substantially prevailing in the party in the action seems to be focused on the action as a whole. So if there's statutory justification for obliging or permitting a trial court to reduce a fee award, because although the party was substantially prevailing, some of the money was spent on arguments that were not successful for the party. I guess that would be in the word reasonable. But do you think that a trial court in assessing reasonable fees at least can, maybe must say, well, this was a substantially prevailing party but $100,000 of what they spent was on claims they didn't prevail on that really were pretty weak, and I'm not going to award them fees for their work on that was discrete and not overlapping. Do you think the trial court can do that, or you think the trial court must do that, or both?
I think the Hensley analysis does not change based upon the language of the statute, in that the court still has to, after determining who is the substantially prevailing party, say, are these claims related? Are they unrelated? So I don't think, the way I read the statute, that it was intended to undo existing case law about what attorney's fees can be recovered. So the way I would see the statute being applied is, if we are the substantially, let's just say Ms. Burton had prevailed. She got her system, she won on a variety of claims, but lost on some. And the first court has to first find that she's a substantially prevailing party, and then assess fees in the same manner that it would under any standard, whether it's prevailing, substantially prevailing. It has to go through and find that the hours were reasonable. And it also then has to go through and do the analysis of, what did you prevail on? What did you not prevail on? So the way I read the statute, I don't think it's intended to be an exception to how a trial court analyzes the reasonableness of fees.
Thank you, counsel.
Thank you.
We'll give you a couple minutes in rebuttal.
Thank you, Your Honors. Yes, I'll be brief. I just wanted to make two quick points. First, with regard to the mootness slash safety argument. First, as far as factually, even what Ms. Tadros read was about having tens of cuts into this wall. So even putting aside the fact that we could have gone through this gap, they're talking about tens of cuts. At the time we made our application, there were 2 people in the entire building with electric vehicles. We were the only people who were asking for a system. So after Ms. Burton was allowed her system, you probably could have gone through the firewall safely, and even though you didn't need to, and then you can change, then bring out Rule S, then narrow the scope of this easement. But more importantly than that, the trial court, the jury heard all this. The jury had the testimony about the safety or non-safety of the system. And the trial court, if the trial court was going, we would not have won on count 4 had the trial court said this is unsafe and it's going to, burn down the building. So this wasn't a matter of being clearly erroneous. The judge shouldn't have had discretion to not order the injunctive relief. And then as far as the bills, this case, as I've kind of said throughout, was about this one issue, and it was quite impossible to separate things out. And we mentioned in our brief.
I don't understand that really. I wouldn't assume that the law were really clear what substantially prevailed meant, and that it was very clear that your ability to get reasonable fees would be contingent on your ability to say, here are the hours that relate to the claim on which we had success. And it might well be that most of the hours would be in that box because there was a common set of related legal issues. I mean, the contract claim and the statutory claim seem, we've said that the verdicts on them are at least arguably or facially inconsistent. So hours that were devoted to one, it seems like pretty obviously would be devoted to those as well, and you wouldn't be able to pull them apart. But it wouldn't be, I don't see why it would be impossible to have either initially or upon someone raising the issue, which may not have been concretely raised until the trial court ruled, to have said, oh yeah, sort of what you say now, but being a little more concrete about it. I mean, what you say now is really almost all the hours relate to the success, to the count on which we had success. Maybe some of it related to the books and didn't. You think maybe some of the fiduciary hours relating to the fiduciary claims might not have been, because some of them might have turned on issues of fiduciary law that you wouldn't really translate. But I don't see why it would be impossible. It seems like it would be quite doable.
Well, I think in this case, Your Honor, I'm going to read from the trial court's decision on summary judgment. The court noted that plaintiff's count 4, which is the count we won, builds off plaintiff's other claims, namely counts 1, 2, and 3. It's in the joint appendix at A66. And then it later said, the court reiterates the same findings made on many of the previous counts when dealing with whether there was a breach of contract. And then it also said, additionally, similar to count 4, the claims for breach of contract arise out of defendants' alleged actions under many of the previous claims in the complaint. The claims for breach of fiduciary duty, request for declaratory judgment, and violation of DC Code Section 42-1902.09A each originate from the obligations between the parties that arise out of the instant contract. Now, could we have maybe tried to pull out discrete research on one issue or another? Potentially, but again, these claims were so intertwined that there was really no way to pull them apart. And again, this just all goes to the fact there was this one big issue in this case.
Right.
And if there's nothing else, Your Honors, we would request that the court reverse the trial court's decision denying declaratory and injunctive relief and remand with instructions to declare the Burtons have the right to install their system according to their plan, and also reverse the trial court's decision to reduce appellant's already reduced fee award by 6/7 and remand with instructions to award the amount requested from the trial court. Thank you very much.
Thank you to counsel for both sides for your arguments today and for your briefs, and the case is now submitted.
Thank you.
We'll hear now the final case on this morning's calendar, Franco versus United States, number 25 CM 273.
Good morning, Your Honors. Jason Clark for Appellant Milton Franco, and I would ask to reserve 3 minutes for rebuttal. Appellant Franco was denied his Sixth Amendment right to a jury trial. To have a jury stand between him and the severe penalty of 15 years of mandatory humiliation and sex offender registration. That the state of Maryland attached the penalty rather than the district was not a valid reason to deprive him of such an important right. What is relevant under the Sixth Amendment analysis, as this court has held in Bordeaux, is the potential penalties to which Franco was actually exposed. And as this court has held in Fallen, the penalty of sex offender registration is a serious penalty that requires a jury trial.
I mean, that sounds like too broad of a statement. So let's just posit that somebody to say that what matters is the penalties to which they're exposed. So let's just say Mr. Franco, so let's say we have a similar situation. The defendant is an 18-year-old, and we know if he's convicted of anything, he will go home and his parents will lay a beating on him severely and every day for the next 2 years. That would be a very severe penalty, but I don't think we would factor that in when determining whether or not they had a right to a jury trial, right?
I think that's right, because that's not state action.
Right. So that's part one, and then part two is, and it also seems to be pretty clear from Supreme Court precedent that the relevant state action needs to be coming from within the jurisdiction where the claim to a trial, where the legislature that we're assessing whether or not they view it as serious or not, with the caveat from Bordeaux that Congress counts because they kind of make rules for everybody in a context like immigration where they're the only ones who can make the rules. But it seems to me from the Supreme Court precedent, we can't just look to what might happen in other states.
I don't think that that is the thrust of the Supreme Court precedent. I think that the Supreme Court precedent was trying to get away from a very complicated totality of the circumstances, look at the historical process or at what somebody was entitled to at the time of the founding. They were trying to get away from that very complicated test. And they wanted to implement something that was simpler. And so they did design this presumptive analysis. And they were hoping that the presumptive rule would take care of most of the problem. And certainly, in order for that presumption to apply, in order to look at the maximum penalty, you have to look at the state legislature that is actually imposing that offense, or whatever the legislature is. But that is only for the presumptive part. I don't think that anything in the Supreme Court's case law certainly does not clearly define or say that we don't look to the other penalties.
Can I ask you you said state action. I want to make sure I understand it. Another hypothetical. Imagine instead that your client had been a citizen of Germany and where he normally resided, and he was here visiting. And Germany would impose sex offender registration on anybody who was convicted in any country of the offense at issue here, so that your client would be, just for what you think is true of Maryland, say everything would be true of Germany. Would you say that that dictates a jury trial in the District of Columbia?
I think that that's a harder question, and off the top of my head, I can't think of any case law that's specific to that. And I'm not aware, certainly between the states and between our jurisdictions, we have, full faith and credit, and that we are, and it would be somewhat inconsistent, I think, with the more historical analysis that the court engaged in before we went to the presumptive test. I think that in the earlier years, the court was looking at sort of the broad consensus and looking at what happened at common law and looking at factors about whether something was say or
And I mean,
otherwise.
I think it's kind of academic what the answer would have been under the system that the Supreme Court abandoned as unworkable.
Right. And I guess
So I'm not sure that
my
will shed
point
much light.
was that what I think that maybe it wouldn't apply. It wouldn't apply what happens in another country because it's not something that we look to. It's not part of the nation's historical traditions, which is
Again, that's not, that was more the old test.
yes.
Under the new test, historical, I mean, Blanton, Nocta, all those cases don't say anything about historical traditions. Their framework. And I mean, I am to a degree sympathetic to the argument you make. It seems to me if the way the Supreme Court had revised its approach when it abandoned the old approach had been to say, there's going to be a petty offense exception, but we're going to determine it by figuring out the impact on the defendant of sanctions the defendant faces. And they will make a presumption that, if part of that impact is 6 months or more of incarceration, then or more than 6 months of incarceration, there'll be a jury trial, but then we can consider other impacts as well. Then it would be easier to understand your argument, which would be from the defendant's perspective, sex offender registration is sex offender registration. He doesn't really care whether the district imposes it on him or Maryland does. He lives in Maryland. He's going to be subject to it. So he should have a jury trial, a jury standing between him and that, imposed kind of mandatory consequence. That has a certain intrinsic logic to it. But I have a hard time reconciling it with what the court in Blanton replaced the old system with, which was very much focused on we are replacing this consensus view with the determination of what the legislature viewed as how serious it was. And we're going to look at these penalties not by saying what's the gravity of it as experienced by the person who's subject to the prosecution, but instead, what are the sanctions that have been selected tell us about how seriously the legislature viewed things? And that focus made it a little tricky in Badeau to incorporate Congress's penalties, but the court explained in Badeau 2 reasons why that was appropriate. One, that Congress, if you're talking about DC, and this is paraphrasing, so feel free to take issue with how I'm paraphrasing it, but one is that, Congress sits over the DC local government, and so it's making a judgment in DC too about the consequences of this and how serious it is. And all of that has to be taken into account for what DC's overall judgment is about how serious it is. And then the other was that the sanction at issue was one that Congress and only Congress can impose. So it's not like DC could say, local DC could say, this is not a serious offense. And part of the reason it's not, part of our evidence that it's not serious is we're not going to deport anybody for it. They can't make that judgment. That's not for DC to make. And if that's the thinking in Badeau and in Blanton, it's a little hard to see how that works with Maryland, because DC did make a judgment on this particular consequence and said, we're not imposing sex offender registration on people who commit this offense. And Maryland is a completely separate sovereign that can make a different judgment, did make a different judgment, but isn't part of the judgment that DC made. And so if that's the analytical framework, I have a hard time seeing how to take Maryland into account. So tell me where you think I'm steering wrong.
I think that DC gets to decide essentially the presumptive step. And so they have said that presumptively it does not, but then the defendant is free to put into the evidence, and as he did in this record, that he was faced to a more severe penalty than otherwise. And I think the point that I was trying to make with the way that the Supreme Court had treated things before the current test was that just that the Supreme Court didn't change the Sixth Amendment protection. The Supreme Court changed the test. They created a safe harbor, I think, for the defendants to say, look, if it's more than 6 months, you're going to get that jury trial right. But it wasn't intended to take away from somebody that can show a severe penalty.
If I can pull you somewhat out relatedly into left field on this, if that's the issue and it's a Sixth Amendment right we all have, and it's someone implying the penalty, it's Maryland that's putting the penalty on. Why wouldn't this better be conceived as a constitutional challenge in Maryland to that registration based on DC determining the crime itself was not serious here?
I think that I'm not sure that that is completely foreclosed by Maryland law. I'm not sure that what the viability of a claim like that would be. It's an interesting question, but certainly I do think that this court's case law in Badeau and Fallon taken together with the Supreme Court case law does stand for the proposition that we have to take in the penalties that a person is exposed to. And once we move beyond that presumptive step, we have to look at everything that that person is exposed to, as long as it's the result of some state action, some legislature has made a decision, and that way it is, I guess, sufficiently objective for us to apply it in the analysis.
You seem at times to be drawing a distinction between the way this might work if you're talking about the presumptive period of incarceration part of the analysis, and instead the additional consequence part of the analysis. And is there a textual basis in Blanton or in any of the cases to support that? I mean, I know when in Blanton, when the court started talking about beyond the incarcerative penalty, other things can affect the outcome. The court said a legislature's view of the seriousness of offense also is imposed in the other penalties that it attaches to the offense. And so it seemed to, when talking about the collateral non-incarcerative penalties, to be in the same analytical framework of saying we're taking those into account, not because we're shifting to an analysis about how those impact the defendant, but instead we're taking them into account as evidence of what we're saying is the test, which is how seriously did the legislature view the offense.
I think there is some ambiguity in Blanton, and while they certainly do talk about a legislature's view, at some point in Blanton, they also discuss a national view, which is more in line with their older test. And there is some ambiguity left in that opinion. And if you look at Nachtikal, which the government relies on heavily for that proposition. I think that if you take that into account and you really look at sort of the background there, where the Ninth Circuit had just refused to apply any presumption whatsoever, and they said, no, you start with the presumption and then go from there. And looking at those together, I don't think that you read that as saying that we're not going to consider something that might have happened in another jurisdiction. It just that it doesn't apply to the presumption itself.
Make sure I'm just not, I'm lost in some sense. And so I want to make sure I understand your argument. So I'm the Noctegal line is penalties in other states are irrelevant to the question whether a particular legislature deemed a particular offense serious. You say, well, that's about the presumptive test. The presumptive test, when you say that, are you referring to the 6 months or more?
Yeah.
I mean, other states never are opposing. I mean, this sentence doesn't make much sense if that's how you think about it, because other states are never imposing additional jail time on people for acts that are committed outside of their jurisdiction. It's not like DC can convict me and if I move to another state, they can also throw me in jail for a while. So we're always talking about collateral statutory penalties. So it would seem a bizarre thing to say that those statutory penalties are irrelevant to the question whether or not this is serious, and mean only as to the presumption being satisfied. Do you see what I'm having a hard time with?
I think I see some of that, and I do think that and that's why there is some confusion, is because the Supreme Court hasn't directly addressed this issue about the collateral consequences that may be coming from state action and some other legislature. It is always going to be the case that the state legislature that created the maximum penalty is the same one that's prosecuting at that point. And so it just hasn't come up in the Supreme Court as far as the direct analysis. But I do think that taking in the totality, and everything that's been said, that you do follow that. And this court, I think, gave a very similar hypothetical in, I believe, footnote 32 of Badeau, where there was the hypothetical that if Congress had come in and said, look, we're going to impose an additional 1-year penalty for these state crimes, then they would have to take that into account. And I would read that footnote as not being to Congress alone, but if Maryland decided to impose an additional 1-year penalty for anyone convicted of a DC offense, and if at the time of trial they were subject to that additional 1-year penalty, I do think that this court would say that that's properly considered under the Sixth Amendment.
I do think, I'm not sure, it is unclear whether that would be lawful for a state jurisdiction to do, but I understand, I'm not trying to fight your hypothetical. What I'm thinking about it is, it brings to mind the question Judge Howard asked, which is there might be a problem with that, but whether the solution to the problem is to require DC, which is trying to treat this as a petty offense under the standards that have been identified, has to have a jury trial that it doesn't think it should have to have, or whether instead there'd be the Sixth Amendment would say, well, DC can do what it wants and impose the penalties it wants, but if Maryland wants to try to impose that additional penalty, it can't do it on someone who didn't have a jury trial. It might be an impediment to the other jurisdiction imposing its consequences, not on dictating that DC give a jury trial for what it is doing everything in its powers to treat as a non-serious petty offense. And that gets me back, I guess, to the kind of anomaly. What happened in Badeau makes sense in a way, in that one way, if the focus is on how seriously does the legislature deem this offense, which is what we seem to be given from Blanton, if the local jurisdiction sets up penalties that make it petty, it's done what it can to make it petty. Well, in Badeau, Congress, who has authority over the district and is able to add on to this, says we're adding some penalties. I mean, the Congress has plenary authority over the district, and it can dictate what the consequences in the district are in a very straightforward way. And it's the only entity that can impose the consequence at issue. It doesn't seem anomalous to have Congress's judgment there kind of trump the efforts of the DC legislature within its sphere of authority to make an offense petty. But it does seem odd to think that if DC legislature says this is not a serious offense, we're not treating it as a serious offense, we're imposing consequences that are consistent with it not being a serious offense, and we're not giving people a jury trial, to say that Maryland, by making its own judgment about the consequences it wants to impose, can require a completely different sovereign to have a jury trial that it doesn't want to have, seems anomalous. So why do you think that's not anomalous, or why do you think that's the do you agree that seems odd, or do you really think that it seems perfectly
I think
reasonable?
that the result and what Mr. Franco is asking for here is his jury trial is perfectly consistent with what this court did in Badeau, and that the language in Badeau is not confined to Congress alone, and that it is going to apply to any sort of state action. And the emphasis of the Sixth Amendment, I think, has to be the protection of the individual right and the ability to have a jury stand between them and some other state action. And I am not concerned with what sovereign is imposing that additional penalty. Only
Well,
that
you are to a degree, I think, at least possibly, if you think Germany's determinations wouldn't dictate a jury trial in the district.
I don't know if there's another historical basis to exclude that. And my primary position that I took in the brief is that essentially this exception, the petty offense exception itself, is not well-founded, was the result of an error in the court's own case law. And I think that the safer approach, and this was pointed out by the court in Badeau, is when in doubt, have a jury trial. Because ultimately having the jury trial is the easy solution, is more consistent with the actual text of the Sixth Amendment, and prevents further litigation, and It's easier to just go ahead and have the jury trial in the first place. And most jurisdictions, that's what they do. We are one of the outlier jurisdictions that's not providing jury trials for most of our misdemeanors. We are an outlier in that. And so I think that as states have demonstrated, it's quite possible to provide the right to a jury trial. So when in doubt, let them have it.
Thank you, Counsel. You're over time. We'll give you your 3 minutes in rebuttal.
May it please the court, David Goodham for the United States. I want to certainly address some of the arguments my opponent has made, and I certainly want to answer some of the questions that the court has. But with the court's indulgence, I'd like to fill a hole, if you will, that I left in my brief. The critical question here, I think, and the court's already alluded to it in its questions, is when we're applying the Blanton test, what is the controlling legislative determination? And that's a phrase Noctegal uses. From the government's perspective, and we think the Supreme Court cases support this, the controlling legislative determination is the legislative determination of the locality that authorized the offense. I'll leave those quotes and those briefs, those citations to our brief.
So that way of formulating it seems inconsistent with the holding of Beddoe.
I don't think it is inconsistent with the holding of Beddoe.
I mean, what you said was that you look to the controlling legislature, and the controlling legislature is the jurisdiction that imposed the offense, the legislature that imposed the offense. And that wasn't true in Beddoe.
I read Beddoe, and obviously there's language on both sides. I read Beddoe as essentially saying that Congress was the enacting legislature when it comes to, is the enacting legislature when it comes to deportable offenses. And I take that reading.
Well, they're enacting the penalty, but they're not enacting the offense.
Essentially, I read Beddoe as saying that that is what's happening here. And I glean that from two features of Beddoe. One, of course, the Beddoe referenced Congress as the national legislature. Beddoe also said, it's the only legislative body that can prescribe the penalty of removal from criminal conviction. And then I think when you look at how they described the immigration consequence of deportability in Beddoe, you see that they're essentially saying that this was Congress enacting a deportable offense. You look at notes 3 and 4 of Beddoe, Beddoe says, Congress, quote, categorized sexual abuse of a minor as an aggravated felony. And Congress, quote, provided that a person convicted of an aggravated felony is deportable. So I think one reading of Beddoe is essentially consistent with Blanton's core holding, if you will, that you look to the locality that authorized the offense. But I didn't answer in my brief, and I'd like to fill that hole right now with the court's indulgence. I didn't answer in my brief why that limitation is important. And conveniently enough, that answer about why it's important comes from a case that was relied upon by both Blanton and Beddoe. In 1988, right before Blanton was decided, the Fifth Circuit had an en banc decision called Landry versus Hepner. And in Landry versus Hepner, I think this is an important explanation for why the controlling legislative determination is confined to the locality that authorized the offense. What Landry says, and this is 840 F second at 1210, when the legislature of a state elects to make criminal certain conduct within that state's borders, it is likewise entitled to determine that the offense it has created shall not be a serious one by fixing for it a maximum penalty, which is conceitedly petty. And Landry goes on to say, what is serious in Vermont may not be serious in Louisiana in terms either of a particular problem's concrete manifestations or of the popular perception or evaluation of it in each of those states. Not only do conditions vary from state to state, but so do people's attitudes, both normative and prudential. I think actually Beddoe follows up on this when it says, and this is 186A3rd at 1257, through the penalties mandated by public officials and elected representatives, the laws and practices of the community are taken as a gauge of its social and ethical judgments. And that's the critical why we limit this to the legislature that authorized the offense. We can't have a situation, I would suggest, I'm sorry.
I was just, there is really no context in which that sounds more artificial than this one. Do you think that the people of the District of Columbia and the DC Council would adjudge Milton Franco's the conduct that he was convicted for as being petty? Sort of in a colloquial sense. No big deal. No big deal.
Well, I think when you talk about colloquial sense, we're actually beckoning back to the exact test that the Supreme Court left in Blanton, which is.
I'm trying to piggyback on the Fifth Circuit's language. What's not serious in Vermont might not be serious here. If that's the way to think about it, I'm pretty sure Mr. Franco's conduct is serious anywhere you look.
Well, again, if we consider the legislative determination of the DC Council, they have concluded that the misdemeanor sexual assault of an adult is not something you have to register for. And what Fallon says is registration is a significant penalty. So, and this is why.
What if I thought, I've never looked into this, but what if we have clear statutory history that says these are some of the worst offenses out there, but if we permit a sentence of no more than 180 days, we can convict people in bench trials instead of jury trials. That saves us a whole lot of time. We still get the benefits of registration. And so let's do that. So 180 days maximum for misdemeanor sexual abuse. We consider that to be a useful tool to skirting jury trials. Do you think it's still petty? Still no right to a jury trial?
I think DC would be entitled to make that determination. There are, of course, burdens associated with jury trials, and Baldwin recognized that. Baldwin said, the availability of speedy and inexpensive non-jury adjudications has the benefits of efficient law enforcement and simplifies judicial administration.
Yeah, I get all that. It's just that it's no longer any kind of gauge for what's serious and what's not.
I think the gauge is what the legislature passed and concluded were the penalties attributable to the offense that is at issue. And, I don't think in that context, once we start getting into legislative history and looking at sort of behind the veil of the statutory language, I would suggest we're beckoning back to the sort of imprecise test that Blanton said we have to get away from. And Blanton and Baldwin recognize this also. When you draw a line, there are going to be cases close to the line, but it's important in this context to have a line. And that's why ultimately the critical question here is, again, what are the parameters of the controlling legislative determination? I would say
why from that angle would it not be fine to draw the line at the DC legislature, the city council has decided that we don't want to apply this serious penalty for it. And in Fallon, we confirmed that we agree that's a serious penalty. DC said they don't want that to happen when this crime is convicted. Why then shouldn't that be the line, and we don't turn a blind eye to when their will is going to be thwarted by an equally or more severe registration that they sought to avoid coming in? Doesn't that from one angle equally frustrate their purpose?
I don't think so. I think, otherwise Maryland's judgment would prevail over the DC Council's judgment. The DC Council is speaking for the citizens of DC. The DC Council is speaking for the problems and the issues facing the citizens of DC. And part of that calculation, for example, could be the court system and what kind of budget they have for that.
I'm not pushing back at all that I see where you're drawing the line. I don't necessarily disagree that that's a reasonable line, but wouldn't you say that equally defeats DC's judgment if DC said, we don't want this penalty attaching to this crime, but now it goes on to attach to the crime based on the conviction in DC?
I don't think so. DC is allowed to define what is serious and petty for the criminal conduct that occurs within the confines of the geographic location of DC. And that's, to my mind, what we're talking about here. You know, Vermont may have an issue with drunk driving, and it may want to attach to a Kentucky DUI offense a permanent lifetime ban on getting a driver's license. But Vermont's problems with DUI can't trump Kentucky's own sort of calculus about what it deems an offense is as serious in Kentucky's geographic confines. Now, again, I recognize, I'm sorry.
Do you agree that, at least in some extreme hypotheticals, that the Sixth Amendment might impose an impediment to the foreign jurisdiction imposing consequences on someone who didn't have a jury trial? So, I mean, imagine Vermont had a problem with its residents committing offenses anywhere. And had like a zero tolerance. If you're, you know, we don't want our residents going around the country committing offenses, and anybody who commits any offense in any other jurisdiction will, if they return to Vermont, be subject to a 1-year term of incarceration. Now, there are a lot of questions about whether that would be a lawful statute, but is the Sixth Amendment one of the problems? Could you say, you know, that doesn't mean that every jurisdiction has to have a jury trial for every offense because Vermont has that view, but it might mean that the Sixth Amendment would permit Vermont from imposing a year of incarceration on people based on a conviction where they had no jury trial.
I can't get over the hump of the significant due process considerations attendant that kind of state rule, but I even in that.
I'm not sure why there would be a due process problem. There might be a variety of problems, but I'm not sure. I mean, presumably the person will have had due process in the state where their conviction was entered.
Perhaps.
So why would they have a right to further
Perhaps.
process on the
Yeah.
question of whether they were guilty of the offense? I think there might be questions of the authority of one state to impose that consequence on conduct in a different state.
Maybe that's a better way to
but-
look at it.
but
But
See if
again,
you can flex your mind to get over that and see whether you think there would be a Sixth Amendment problem as well.
My answer would still be the same. I just think that we have to, this is particularly.
Tell me what you think the same answer is, because the
Same answer is Vermont can make that determination.
as it relates to the local jurisdiction having to have a jury trial or not. My question is,
sorry.
do you think that there is at least potentially a Sixth Amendment problem, leave aside what other problems there might be, if Vermont wanted to take a non-jury trial and attach a year of incarceration to it without a jury trial? That might be, do you think that could be a Sixth Amendment problem? Because that's a consequence that Vermont can't impose on people who didn't get a jury trial based on their conviction wherever they had it.
I don't see that. The logical through point of my analysis, I think, is that is not a Sixth Amendment problem. You know, but again, one thing I do want to recognize here is that the reason that we need to understand and have a bright line rule with respect to the controlling legislative determination here is that in both Fallon and Badeau, they both said, we find unhelpful the sort of civil criminal distinction, the collateral direct distinction when we're talking about deportation and sex offender registration. That means that because, of course, the government proffered those types of arguments in both those cases, Badeau and Fallon put those aside and said, we don't find that helpful. That means from moving forward, the critical question is the one we're discussing here, which is what are the confines, what are the contours of the controlling legislative determination? And again, I think that's easily answerable, particularly when we're talking about different states. I mean, here we have Maryland, who's made an entirely different judgment about sex offender registration than DC. Maryland would be completely usurping the will of DC in that context. It becomes, I understand, a tad more complicated when we're talking about Congress. As I've articulated, I believe at a minimum, I believe one reading of Badeau is a narrow one relating to just deportability. At a minimum, at most, I'm sorry, Badeau can't be read as answering the question here, which relates to two separate state sovereigns. Congress, as Badeau recognized, was a national legislature.
So I want to make sure I understand what you think the narrow reading of Badeau would imply. So let's say Congress tomorrow passed a law that said, I know that, you know, DC thinks that it's local sex offender registration statute doesn't require registration for this offense, but we're going to require that there is that registration in DC. You would say no jury trial.
That's
Because
exactly right. Yeah. And again, I understand this court and there's conflicting language in Badeau, but I understand the import of the strands of the Badeau analysis, particularly its focus on deportability, is something only Congress can do to limit it to those types of offenses. But even if
Granted, it was a footnote, but footnote 32 in Badeau to that section talked about the hypothetical of Congress, much like Judge Deal's question, putting on an extra year on top of a 6-month petty offense.
Sure. And again, that's to my mind, sort of the tension that I see in Badeau. I'm just trying to take what I see in Badeau and what I read in Badeau and have a clean analytical through line. At a minimum, however, I would be remiss if I sat down before making clear that Badeau, even in its most expansive reading, is confined to the situation where Congress has spoken. That is the national legislature that reflects the norms and the ethics and the judgments of the country as a whole. We don't have that type of judgment here. And in that respect, I would suggest that he was properly denied his jury trial, right? A jury trial here, and we would ask that you affirm the judgment.
You say that that's the broadest reading of Badeau, but if you take, there are a couple of sentences in Badeau before there's a focus on Congress that some of which your opponent relies on that seem broader. The sentences that say, instead, the seriousness of an offense is to be assessed by reference to objective standards penalties resulting from state action, e.g. those mandated by statute or regulation, not limited to Congress, not limited to the jurisdiction that is the controlling jurisdiction. It's general, is that sentence. And then the following sentence is through the penalties mandated by public officials and elected representatives, the laws and practices of the community, that part may be somewhat helpful to you, are taken as a gauge of its social and ethical judgments. But at least the first of those sentences seems broader, potentially.
Concede, but I think you have to read Badeau in the context of Blanton and Noctegal and Lewis. And I don't understand Badeau to be standing for the proposition that we are fighting the landscape that has been articulated by Blanton, Noctegal, and Lewis.
So I think Mr. Clark's, I went back, I think footnote 11 in Badeau is, in Blanton is the relevant discussion of this. And then Noctegal just cites that footnote 11 again. And it does seem, when you look at footnote 11, that it is rejecting the sort of prior view about how to determine whether or not something was serious, like through a national survey of how, it doesn't seem to be talking about collateral consequences. That's, read most broadly, you could read it that way. But it seems to be rejecting a view that, well, look across the nation at states and come up with a national consensus of whether or not this is serious. And Blanton says, no, we're not going to do that. This Nevada only attached this amount of penalty. But, there's a lot of collateral consequences that are routinely felt across the country. If you have a domestic violence conviction, you might lose your Second Amendment rights to possess firearms in various states. Sex offender registration. I don't know how many states Mr. Franco would have to register in light of this offense. I assume it's not just Maryland, and there's probably quite a number. And so I'm not, I'm becoming a little iffy on whether or not Blanton and Noctegal have answered this. And then when I looked at the briefs, I don't see people citing to a lot of, I know it hasn't been decided by us. I don't see a lot of outside of this jurisdiction discussion. I know Badeau talks about 2 SORA cases that I think were from district courts in California. I think that's footnote 31 of Badeau. Are there cases, do you have sort of like here's my best case that's actually really delved into this that you want to point me to?
I was gonna cite the same ones that Badeau pushes. They are cited in the law review article that we cited at page 18 of our brief. And those are the 2 apparently, and they are unpublished for sure, but they stand for the proposition that potential sex offender requirements imposed by a separate sovereign upon conviction should not be a basis for triggering a jury trial right. I guess I disagree with the sort of your core premise, which is that Blanton and Noctegal don't speak to this. And, you know, from my perspective, the best language from Blanton that supports the government's position here is at page 541 of Blanton. In fixing the maximum penalty for a crime, a legislature includes within the definition of the crime itself a judgment about the seriousness of the offense. And to my mind, that is, you know, and a legislature, that's not so helpful. But here, I think what they're saying is we look to the definition of the legislature whose offense is at issue.
Let me ask you one final admittedly overbroad question. Where's the harm here if we allowed the trial courts here, when a party brings it up, to look at the collateral consequences in other jurisdictions that an individual defendant may be subject to, particularly here in DC, where we exist in you know, I could stretch it and call it a quad state region, where there are multiple other jurisdictions that you may potentially be subject to collateral consequences from. And I fully acknowledge an easy part of the answer is, well, you chose to come into DC and engage in this activity. But where's the harm to our system?
I think it's twofold. It's both, it's sort of, there's one sort of deeply philosophical harm, and there's another more prudential, practical harm. And this, I mean, I think Your Honor's question is sort of like, why not a jury trial? Let's just err on the side of caution. Well, again, I think there's something for the notion that you can't have one jurisdiction, a separate sovereign, dictating the procedural protections of a jury to another jurisdiction who has arrived at a different conclusion. That's sort of the 60,000-foot level. The 10-foot level, if you will, is that it's not, you know, again, you know, Baldwin recognizes this is not just sort of no harm, no foul scenario. There are burdens. There's a reason DC passed the Jury Trial Streamlining Act. You don't want to clog up the courts with offenses that DC Council has determined don't puncture that 6-month imprisonment presumption.
If I could ask, perhaps somewhat facetiously, I assume you would argue then we should not take into consideration at all the act that ultimately didn't pass congressional review when City Council tried to re-expand some of those misdemeanor trial rights that had previously got rid of.
I don't think so. I mean, I'm sorry to interrupt you, Your Honor. I think Blanton stands for the proposition that we want bright lines rules. One bright line rule is you glean from the statutory language that the DC Council has signed off on. We would ask that you affirm the judgment conviction below. Thank you.
Thank you, counsel. You have 3 minutes in rebuttal.
Thank you. Judge Howard, I think you made the point that I was going to make, that was that our local legislature, our city council, did try to give individuals the jury right here. And so if to the extent that we're going to consider that.
Although not by imposing SORA consequences, but rather as a matter of sort of legislative policy about what it wanted to do as far as according jury trial rights to folks.
Yes, and to bring the district into a line with what most other jurisdictions are doing. And so I think that we can clearly see that the harm here is not significant on the district. And I'll also point out that in these cases, or as the court has seen, the usual response of the government when somebody has a jury trial right in misdemeanors is that they amend the information to take away whatever is triggering that jury trial right. You can see that in the court's case in Medellin, where he was a non-citizen and they amended the information to make it a non-deportable offense. And that is the consistent practice that I've seen in the Superior Court over the last 15 years, is that simply, and so I don't think that there's going to be a large effect or a large number of jury trials that would occur as a result of this. The court has expanded that right as far as non-citizens, as far as actual, SORA registration for citizens in the district. We have not seen the system collapse, and so I do not think that there is going to be a significant number of people that are ever actually going to get a jury trial as a result of this court's decision.
So since you brought up that the attempt that city council made to pass legislation to re-expand the misdemeanor trial right, do you think that emphasizes the point your opposing counsel is making in Badeau, that really Congress is a different beast in the sense that Congress is who prevented that from going into effect here? And so they do have a special relationship to us, and that is something different than a completely separate sovereign that has no real relation to us.
We are something of a different beast, but if we're looking to the objective sort of community values, as I think the government would want to say it, and relying on the legislature for that objective evaluation of whether or not something is petty or serious, then I think you have to look more at what the city council is doing, because they are the actual representatives of the local population, not so much Congress in this case. But of course, I would say, and I also wanted to touch on the government's cite to Landry v. Hopfner. And I think that this court addressed it. It was a footnote 31 of Badeau. And really there, I think this court read Hopfner as saying, that's the reason that we the presumptive test looks to the local legislatures, because that is the best objective starting point. But it is not the end all be all of the test. And so Landry v. Hopfner stands for the proposition, or a good argument as to why we start with the presumptive test, but not why it ends there.
Can I just ask you the same question I asked opposing counsel, which is, there are these two cases that are talked about in footnote 31 of Badeau, where apparently your argument was rejected, I believe, in some unpublished trial court decisions. There was a SORA consequence attendant to a conviction where there was no jury trial right. I think Mr. Goodhand said, well, read those, and sort of suggested maybe I read Paul Crane's article as well. Do you have something you want to point me to in terms of, just kind of it's surprising to me that this hasn't been fleshed out somewhere, that somebody must have talked intelligently about all this. So I just want to give you both your best shot of, I'll pick up the thing and read what you tell me to read. So I'll read what Mr. Goodhand wants, and I'll read what you want me to read. So what would you like me to read?
I'll say at first glance, it does seem somewhat surprising, except that the district is an outlier in the way that we don't grant jury trials. And so in most other states, it's not an issue because they would just get a jury trial. And as far as sort of my best defense or my best takedown of those cases, it was made by this court in Badeau. This court pulled them apart. It explained why they were based on case law that had either, I think, been abrogated or substantially undermined, as this court put it. And this court went through and I think methodically and correctly explained why those cases don't apply here, are not good law, and are not consistent with the current understanding of the Sixth Amendment. And so,
well, that I've already read, so that makes my homework easier.
All right. And if there's nothing further, I would ask this court to reverse Mr. Franco's conviction and remand for a new jury trial.
Counsel, we thank both parties for their briefs and their arguments. The case is submitted, and we will now stand in recess.